Student number 5, the learning council for the teacher seeks permission to withdraw this application, which is dismissed as withdrawn. I mentioned this.
Notification of order passed.
आज इसकी last working day है. बड़ी जल्दी हो जाए आपको. You can't do it. चलिए call करिए.
From Superintendent for orders DT.15.05.2026 of 2024.
Yes. What do you mean as soon as? No, how much time will they take? Madam, you ask them how much time will they take. If it is in the process, they must be knowing that how much time they will take.
Time they haven't mentioned it.
I told you on the last day also. Go and seek instructions from them. That how much time will they take? The case cannot stop because of their inaction and their lethargy, right? When was it sent to them?
The report is of day before yesterday.
No, when was it sent to them?
The samples.
Yes? Ask them to join online. Ask them to join online at 2:15. Right? And ask them to give the date on which it was sent. When was it sent to them?
30/10/2023.
30/10/23.
Almost 2.5 years, more than.
We prosecute them. We are going to prosecute them. You get it? Ask them to join online. 23 से लेके FSL. They are absolutely incompetent, or they have their own motives. नहीं सकते हैं ना, मना कर देना चाहिए वहीं पर. हम लोग दूसरी जगह भेज देंगे. You be there at 2:15, right? You provide me the data. 2:15, you ask them to join.
Perfect spelling item 2 BA 4247 of 2026.
Yes.
The case number 376 corresponding section. First FIR and deposition.
No, it's coming for the first time.
First time
You call. Yes.
एक चीज खाली दिखा रहा है जो भी करना चाहेंगे उसमें कहीं कोई दिक्कत नहीं. डिपोजिशन हो गया है लड़की का, हम खाली दिखा रहे हैं कि कुछ हुआ ही नहीं था मेरे ऊपर केस. हम 1 साल 9 महीना से हैं, इतना करीब है, आज तक बेल भी फाइल नहीं किया.
स्टेज क्या है? 11-12 का ऑर्डर है. स्टेज क्या है किसका? How many witnesses have been examined?
में से 5 हुआ, खाली देख लिया जाता है. 15 डिपोजिशन से पूछा देख लिया जाता है.
ठीक है. कहाँ?
पेज 50.
Yes. पढ़ी? Please read.
यस सर. घटना आज से लगभग 1.5 साल पहले की है. उस समय मैं 8वीं में उत्तीर्ण विद्यालय धनबाद में पढ़ती थी. उस समय मैं अपने घर से गुस्सा होकर निकल गई. अपने दोस्त पिटिशनर नाजिर अंसारी के पास कुछ बिहार चली गई. उसके एक दिन बाद चाचा नाना पुलिस मुझे कुछ बिहार से लेकर आए. उसके बाद केस नाजिर को जेल में दिया. मेरा दोस्त नाजिर का कोई गलती नहीं है, नाजिर बेकसूर है. आज मैं मजिस्ट्रेट साहब के समक्ष बयान दी थी जिस पर मेरा हस्ताक्षर है, पहचानती हूँ. हस्ताक्षर सचन सच है. मेरा डॉक्टरी जांच हुआ था, पुलिस द्वारा बनाया गया डॉक्टरी जांच में अपना हस्ताक्षर बनाई थी. यही मेरा हस्ताक्षर है, पहचानती हूँ. सचन सच अंकित किया गया था. वीडियो कॉन्फ्रेंसिंग सिस्टम के माध्यम से प्रस्तुत किया गया. अभी नाजिर अंसारी अपराधी को पहचानती हूँ. मैं अपने मन से घर से गई थी, मन से घर से वापस आई थी. मेरी मुलाकात कुछ बिहार में नाजिर के साथ कहीं नहीं हुई. हम मुझे मेरे नाना घर में थे, हमसे भेंट भी नहीं हुआ. मुझे पुलिस कुछ बिहार रेलवे स्टेशन से लेकर आई थी. अरे क्या FIR खड़ी, थोड़ा सा FIR देख लिया जाए, एलिगेशन क्या है. दैट इज पेज 14. सभी ने निवेदन किया है कि रहमान अंसारी, सचन सच, फिरोज अंसारी धनपुर, सचन सच दुमका का निवासी आज दिनांक 4/8/24 को रात करीब 11 बजे और मेरे बेटे के सभी लोग सोए हुए थे. मेरी पत्नी मुझे जगाकर बोली कि मेरी बेटी करिश्मा खातून अपने बिस्तर पर नहीं है और घर में भी नहीं है. तब मैं अपने बेटे घर से सभी सदस्य अपनी बेटी
BA number 4247 of 2026. Or the learning council opinion on behalf of the petitioner. The learning council for the petitioner has submitted that. when victim was found missing from home, it was alleged that she has eloped with the petitioner, and the case was instituted. She has submitted that the victim has been examined before the court, and she has completely, she has not supported the case of the prosecution at all. Rather, she has said that she had herself gone to her grandparents and she did not meet the petitioner at that place. And the petitioner is totally innocent. Is somebody said the petitioner is in custody since?
8/8/2024.
After hearing the learned counsel for the petitioner and upon going through the deposition of the victim and considering the custody of the petitioner is directed to the national. Opposite party absent.
For admission item 3 BA 1112 of 2026.
These are registered under section 82 and 35 of the
Just a minute.
petitioner is the mother-in-law of the deceased.
What is the date of marriage? Date of marriage?
In the year 21 also.
Where did she die?
Sasural.
Matrimonial home?
Yes,
In what manner?
अभी तक ऑफिशियल रिपोर्ट भी नहीं आया मैडम, दूसरा का रिपोर्ट भी नहीं आया है।
Found dead, no?
Yes, sir.
Found hanging, what happened?
No.
Then?
जमीन पे ये लोग लेटे हुए थे। इनके मतलब petitioner के ऊपर कोई स्पेसिफिक एलिगेशन नहीं है।
FSU report कहाँ है इसमें?
नहीं आया है।
ऑफिशियल रिपोर्ट नहीं आया है, लेकिन दिया हुआ है कि स्टोमक में बोलता है पॉइजनस
And there is no antemortem injury.
charge sheet has been submitted.
Petitioner is in custody since 2/8/25 years. It's 9 months.
Or the learning counsel supporting on behalf of the parties. The learning counsel for the petitioner submits that petitioner is the mother-in-law who is in custody since
2/8/2025.
2/8/2025. And the petitioner has been falsely indicated in this case. The learning counsel has further submitted that the FSL report has not been received so far, and therefore the cause of death will not be ascertained. He has referred to the improved order itself. The learning counsel for the state has opposed the prayer. However, during the course of hearing, it is not in dispute that the marriage had occurred on in the year 2021, and she was found dead in her matrimonial home on 31
31/7/25.
31/7/2025, and it has been alleged. Just a moment. In the FIR that the petitioner and also the husband, Sanjay Yadav, used to torture the victim for want of, on demand of dowry. The improved order reveals that, as per postmortem report, the victim died due to hemorrhage and shock, and the entire jaw suffered from injury and swelling, and there were signs of scratches on her right hand. Considering the fact that the victim has died in matrimonial home within 4 years of marriage, and antemortem injuries have been found, the petitioner is, this court is not inclined to enlarge the petition on bail, and there is direct allegation against the petitioner with regard to demand of dowry. This court is not inclined to enlarge the petition on bail. However, the status of the case reveals that out of 12 witnesses, 5 witnesses have already been examined. The state is directed to produce the remaining witnesses promptly. Counsel for the state is directed to communicate this order to the SP and to the director of the state.
Item 4, DT.15.05.2026 of 2026 along with item 6.
Please, Charge sheet has already been submitted. The petition of this petitioner is the recovery of license to start.
There is one antecedent.
In that case, he has already been executed. So I have placed the order.
जो अचानक ब्लैक पेपर आता है इसको देख के हम डर जाते हैं. But you see, the experience has been so bad.
Yes, exactly.
And it has been so shocking that it is.
The last one that he had given is in
Charge sheet submitted.
Charge sheet submitted.
How much? What is the 3 mobile, 1 SIM?
3 mobile, 1 SIM.
No victim.
1 victim.
1.
Yes.
Yes, state कहाँ है? Heard the learned counsel appearing on behalf of the petitioner. Nobody appears on behalf of the state. The learned counsel for the petition submits that, though in the counter affidavit it has been reported that the petitioner has one criminal antecedent, but he has been acquitted in the same case. A photocopy of the order of acquittal has been produced before this court. It submits that the learned counsel further submits that 3 mobile, 1 SIM have been recovered from the possession of the petitioner, and charge sheet has been submitted on
13/5/26.
30/5/2026.
8/5, sorry.
8/5/26, and 1 victim has been identified. After hearing the learned counsel for the petitioner and या कहाँ से बोल रहे हैं 1 victim? Is there anything
यस
काउंटर में होगा?
चार्जशीट में है
चार्ज शीट में
Here, in the road.
चार्जशीट में
दिखाई दे चार्ज शीट. चार्ज शीट दिखाई. the learned counsel for the petition has also produced a copy of the charge sheet in support of this submission. One victim. Just a minute. Mr. Silent Tiwari. One victim. एक विड्रॉ हो चुका. He's not there in this case.
I don't find them.
Considering the aforesaid submissions, the charge sheet having been submitted, and it cannot be said that petitioner has any criminal antecedent. The petitioner is ready to be enlarged on bail. इसमें लगा दीजिएगा. Respondent का absence record करेंगे.
6 में भी एक victim है. No criminal antecedent.
One victim.
No antecedent.
No antecedent.
Yes.
The learned counsel for the petitioner submits that the petitioner is in custody
Since 22/2026.
22/2026 and charge sheet has been submitted
Yes, that just
on
8/5/2026.
8/5/2026. What has been recovered from you?
3 mobiles, 3 SIM.
He submits that 3 mobile and 3 SIMs are alleged to have been recovered from the possession of the petitioner, and the petitioner has no criminal antecedent, and no victim has been identified.
No, one victim.
One victim has been identified. The learned counsel for the state has opposed the prayer for bail, but the aforesaid submissions are not in dispute. Considering the aforesaid facts and circumstances, and the charge sheet having been submitted, and petitioner having no criminal antecedent, the petitioner is directed to be enlarged on bail. नहीं अभी नीचे उसमें कोई थे नहीं इसी के देखना सर स्टेट नहीं थे उसमें.
Item 7 BA 2784 of 2026.
petitioner. Yes.
Just want to notice something issue.
Please further. Yes, please. Who are you?
And for the petitioner, I'm really possible solution.
Asover. Asover आज कहाँ?
नहीं
हाँ? आज कहाँ पासओवर होगा आपको?
नहीं पास ओवर नहीं हम पीछे
अच्छा चलो. हाँ बताइए. आप अपने जूनियर को बहस करने का मौका दिया
नहीं
करें.
हम
He is a very hard-working person. He has worked with me as for some time as intern. Internship में मेरे साथ क्या I've seen him. He is very hardworking. काम करते हैं कि नहीं ठीक से? हाँ? He has lot of commitment to practice. This is what I found. हाँ बोलिए.
in this case also
Yes.
the petitioner is solemnized marriage with the informant also
Date
on 24
24.
24 to 2023 also that I have annexed and issued 2 laws.
That's right.
Thereafter also we also gave birth to a child also that I have admitted also. And still resume the conjugal life with the informant also. But there is an allegation that he solemnized second marriage. That has come also, but it is not denied that he has solemnized marriage, but that has come he is solemnized. तो मेरा इसमें इतना ही कहना है कि अगर ये रहेंगे बोले तो शादी हुआ है बच्चा हुआ है अगर ये रहना चाहते हैं हम रखने के लिए
कैसे रहेंगे? कैसे रहेंगे?
बच्चा है
बच्चा है तो अकेले में रहिए, वो बच्चे के साथ रहेगी आपके घर.
सोल्यूशन नहीं होगा हम यही बात है
तो आप शादी जब दूसरा कर लिए हैं, क्या ही
तो डिनाई कर रहा है। आज भी हम मतलब एफिडेविट में हम अभी भी पूछे तो बोला नहीं किए हैं साथ।
असॉल्ट भी है,
Yes.
बर्न इंजरी भी है।
हाथ चला दिया. And she has threatened to my life. I had a conversation with the victim yesterday. She said that she has threatened to the person's release.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that after some argument when this court was not inclined to enlarge the petition on bail, the counsel for the petitioner seeks permission to withdraw this bail application, which is hereby discussed as written. अपना appearance for informant. Couldn't get your name. Sorry, so Apurva Singh.
Supplementary of the recording.
Supplementary affidavit filed by the opposite party is taken on record.
Item 8 DA.15.05 of 2026.
Yes. Yes, please.
Under 96, 64 2 of the BNS and 4 and 8 of the POSCO Act. The occurrence is of 16/1/2026. Ladishima, can you see the
Charge sheet 17.
diary was called for?
Yes.
Page 16 is the relevant portion of the FIR.
Yes. 16 of the brief, right? Right. Read it, please. Read it, please.
Sorry. Like मैं सच ग्राम सच जिला नामकरा का निवासी हूँ। मैं लाचार गरीब विधवा महिला हूँ। मैया मातो पिता श्रीपति मातो ग्राम बनी बीडीसी टोला थाना जिला जामताड़ा मेरे घर के बगल में मुर्गा के पिटिशनर रोशनी। हम लोग उनके दुकान से खरीदारी करते हैं। ये हमारे रिश्तेदार है जो मेरी पुत्री चंचला कुमारी को गाँव के चाचा लगते हैं। इसके द्वारा मेरी पुत्री को काफी दिन से पाला पोसा कर जबरदस्ती शारीरिक संबंध बनाया। जब हम लोग इनको विरोध किया तो दिनांक 4/1/2026 को रात्रि 2 बजे पहला फुसला कर घर से भगा कर ले गए। मैंने गांव के सारे लोग से रात्रि में बताया कि ये व्यक्ति मेरे पुत्री को भगा के ले गए। ये व्यक्ति 2 शादी कर चुका है और दूसरी पत्नी से 2 बच्चा है।
Victim का age क्या?
सब 17 years 17 years 11 months.
Petitioner is 42 years old.
This
And she has supported the statement under section
I'm
1.
only on certain paragraphs of this. When the police took her for medical examination, she is refused for that. I'm only see just 2 paragraphs of this case diary I will read. Para 87 इस उस समय सदर अस्पताल जामताड़ा पहुंचा था। अभिलेख कार्यालय में कर्मचारी से संपर्क किया। उसके उपरांत अभिलेख कर्मचारी द्वारा पीड़िता का पूरा चिकित्सक जांच प्रतिवेदन उपलब्ध कराया गया, जिसमें अवलोकन से ज्ञात हुआ कि प्रेगनेंसी ड्यू टू नॉन-एबिलिटी अल्ट्रासाउंड ऑन द बेसिस ऑफ द लैब रिपोर्ट्स नो ओपिनियन कैन बी गिवन वेदर देयर वाज सेक्सुअल असॉल्ट और नॉट। Thereafter one paragraph 80 first 71 उस समय सदर अस्पताल पहुंचा तथा अभिलेख कार्यालय में कर्मचारी से संपर्क किया। उसके उपरांत अभिलेख कर्मचारी द्वारा पीड़ित का मूल चिकित्सक जांच प्रतिवेदन उपलब्ध कराया गया, जिससे अभिलेखन से ज्ञात हुआ चिकित्सक द्वारा
पैरा
71
पैरा 55 के बाद तो सीधे पैरा 101 में सर है। 101 66 के बाद सीधे मेरे पास पैरा 95
कंप्लीट डायरी नहीं है।
बताइए क्या बोलना है आप
सिर्फ
बताइए।
इतना ही बोलना हूँ कि 63 the 63 is there. That is 63.
ये 63
71.
8/2/2008
Yeah, 71 and 73.
71-73 क्या बोलना है आपको बताइए। ये सब पेजेस आपके पास हैं मेरे पास नहीं।
हाँ,
बताइए क्या बोलना है आपको।
इतना ही है कि वह एक हम सिर्फ पढ़ दे उस समय कर्मचारी उपलब्ध कराया गया रिपोर्ट का अवलोकन ज्ञात हुआ कि मूल चिकित्सक प्रतिगमन डॉक्टर का ओपिनियन रिजर्व रखा है। तत्पश्चात महिला चिकित्सक से संपर्क कर ओपिनियन रिजर्व रखने के बारे में पूछा तो उनके द्वारा बताया कि पीड़िता द्वारा उसका माता अष्टमा देवी द्वारा चिकित्सक जांच के दौरान गर्भावस्था के संबंधी जांच करने में मना कर दिया, जिसके कारण ओपिनियन रिजर्व रखा गया था तथा महिला चिकित्सक द्वारा मुझे सलाह दिया कि आप भी अपने स्तर से उपयुक्त जांच के संबंध में पीड़िता उनकी मां से संपर्क कर पूछ ले। उपयुक्त जिससे ऊपर फाइनल चिकित्सक ने जांच पत्र जारी कर दिए। उल्लेखनीय है कि जब मैंने महिला चिकित्सक से पीड़िता का चिकित्सक जांच के दौरान वस्त्र का संरक्षित करने के बारे में पूछा तो उनके द्वारा बताया गया कि पीड़िता द्वारा अपने कपड़े को भी धो लिया गया और जांच हेतु किसी प्रकार का अंश नहीं बचा, इस कारण से पीड़ित वस्त्र को भी सुरक्षित नहीं रखा गया। एंड देयरआफ्टर पैरा 80 कि महिला चिकित्सक उपस्थित बाधिनी एवं पीड़िता से सलाह देते थे जांच करने हेतु तो अनुरोध किया तो उनके द्वारा गर्भावस्था के संबंध किसी तरह का जांच करने में मना कर दिया। I'm only on this.
Did she say that she became pregnant? ऐसा तो
No. She has not
cooperated
for the medical examination.
ऐसा कोई लॉ है क्या मेडिकल एग्जाम
No,
में
if
बिना कंडीशन?
no law in a start. Why they are when Supreme Court has stated a victim on the statement of the victim a person can be convicted if it is and it is just should be a sterling witness, my lord. And if some doubt is there, then the overruling facts of the case have to be seen, my lord. I am only on the conduct that what has stopped her when she has gone. I am not on the pregnancy. She has not even kept anything to say, and there is no. And admittedly, at 2 o'clock, Bala Bugla ka 17 years, 11 months. It's not that only 1 month limit. So if a person is 17 years, at least he should understand the consequences if she is going somewhere with some unknown person. I'm only on this, and thereafter, admittedly, my lord, I'm on to think that why her mother and she has refused for the medical test and not kept anything that technically or medically can be examined, my lord. I was only on this, my lord. It's true, my lord. When a person is trying to implicate me, he will take all the things which is bestly possible. Obviously, he will not support the case of the prosecution under 183 also. He will, and that Supreme Court is saying in a decision that if somebody is alleging a false allegation against someone, obviously he will prepare a case in such a manner so that his case should be proved. So I am only on this, my lord. A 17-year-old, so medical examination plays a great role in this, that whether any sexual violence or anything has ever happened. So why she has refused, or why the mother has stated that no, my daughter will not go through any medical examination. That is one of the points, and all the witnesses are saying. And with regard to thing, विद्यालय प्रतिनिधि ने निर्गत किए गए जन्म तिथि के पत्रक 13/1/26 के मूल प्रति विद्यालय 8/2/2008. The date of birth is 8/2/2008 and the date of occurrence is 4/1/26. 4/1/26. That calculation में 17 साल 11 महीना हो रहा है. सिर्फ इतना ही होना था कि
The learned counsel opinion on behalf of the learned counsel for the petition submits that on the date of occurrence, that is on 4/1/2026, the victim was 17 years 11 months of age, and she has and it has been alleged against the petitioner, who is 42 years of age, that he had enticed the victim and has committed sexual offence against the victim. The learned counsel submits that mere statement is not sufficient, and the conduct of the victim is also required to be seen. Who has not fully cooperated with the medical examination, and accordingly no opinion could be given by the concerned doctor. And further, charge has been framed and
Witnesses are not been examined that have stated on the status.
the learned counsel for the state has also failed and has submitted that there is direct allegation against the petitioner. The perusal of the case diary reveals that the witnesses have supported the prosecution case, and it has also been stated by the witnesses that prior to 4/1/2026, the petitioner has been exploiting the victim, and the villagers had also warned the petitioner. But in spite of that, on 4/1/2026, the petitioner had taken away the victim. In view of the statement of the independent witnesses recorded in the case diary, that is there.
One statement.
Just a moment. The victim has also supported the prosecution case in a statement recorded under section 183 DSS.
In that statement only, according to all the villagers, that I used to every time disturb her, and first that has not been mentioned anywhere. That there was any such thing which has been stated by the independent witnesses of the village.
If you want any observation of expeditious trial, I will. At this, the learned counsel for the petitioner submits that appropriate observation may be given so that the trial is expedited. The state is directed to ensure that the witnesses are produced before the court. Once the trial commences, the counsel for the state is directed to communicate this order to the SPA of the concerned. एक बार एविडेंस के लिए आ जाएगा. चार्ज फ्रेम हो चुका है.
चार्ज फ्रेम का एविडेंस का स्टेटमेंट चल रहा है.
अच्छा ये मत लिखिए, है ना. I directed to promptly produce the witnesses before the court. The counsel for the state is directed to communicate this order via the communication.
Item 9, PA 3065 of 2026.
Sorry?
Serial number 2,
It's कुछ नहीं होगा. ऐसे नहीं रिकॉर्ड होता है यहाँ पे. Unfair means in examination.
जो प्रोसिक्यूशन का केस कि इन्फॉर्मेंट जो है सेक्रेटरी
देख लेना क्या चल रहा है पूरे इंडिया में.
नहीं वो वाला कहानी इसमें
क्या कहा?
क्या कहानी इसमें है कि
IIT मेंस का एग्जाम
नहीं ये जेई मेंस.
हाँ
जेई मेंस का एग्जाम शेड्यूल था 2/4/2026. उसके पहले जो डेट ऑफ ऑकरेंस है 3/3/2026. 3/3/2026 को ही इंफॉर्मेशन मिलता है.
डेट कब था?
डेट है एग्जाम का 2/4/2026. डेट ऑफ ऑकरेंस है 30/3/2026. 3 दिन पहले. एज पर द इंफॉर्मेंट्स केस
आपका टैशूट हो गया?
हाँ
चार्जशीट हो गया?
चार्जशीट इन्वेस्टिगेशन कंप्लीट रहेगी, इससे मतलब कंक्लूडिंग
चार्जशीट के बाद आइए।
तो उसको वेकेशन के बाद करेंगे, क्योंकि अभी तक चार्जशीट नहीं हुआ इन्वेस्टिगेशन हुआ, लेकिन इसके अगेंस्ट में पिटिशनर के अगेंस्ट में जो प्रोसिक्यूशन का केस है, इन्फॉर्मेंट को इन्फॉर्मेशन मिलता है अपने कॉलेज के एम्प्लॉय से, इन्फॉर्मेंट है सेक्रेटरी हैं कॉलेज के राधा गोविंद यूनिवर्सिटी के, उनको उनका एक एम्प्लॉय उमेश कुमार इन्फॉर्म करता है कि एक एम्प्लॉय उनके कॉलेज का दिनेश महतो और राजेश कुमार टीसीएस का एम्प्लॉय है, वो दोनों लोग कंप्यूटर लैब में कंप्यूटर का सॉफ्टवेयर चेंज अपग्रेड कर रहे हैं और कंप्यूटर चेंज कर रहे हैं। उसके बेसिस पे इंफॉर्मेशन के बेसिस पे जो सेक्रेटरी है वो प्रोसीड करता है, एक केस लॉन्च करता है हमारे अगेंस्ट है कि हम कैंपस के
You
अंदर
have been caught with 50-60 computer systems along with fabricated softwares at the place of occurrence.
हमारे गाड़ी एक फॉर्च्यूनर व्हीकल है, उसमें कंप्यूटर सिस्टम्स रखा हुआ है, इनको इन्फॉर्मेशन होता है, आता है पुलिस एप्रीहेंड करता है। मेरे अगेंस्ट में एलिगेशन ना सॉफ्टवेयर चेंज करने का है ना कंप्यूटर चेंज करने का, मेरे अगेंस्ट है
For the learned counsel's opinion on behalf of the parties, the learned counsel for the petitioner submits that the IIT, the G mains examination was fixed on 2/4/2026 and the earliest date of occurrence is 30/3/2026, wherein it is alleged that the petitioner was involved in an organized crime and was caught red-handed with 50-60 computer systems along with some fabricated software at the place of occurrence itself.
This petitioner
The
is having no
counsel for
criminal
the
antecedent.
petitioner, sorry,
He is having no criminal antecedent.
the petitioner is having no criminal antecedent.
And on the earliest date of occurrence, as per the petitioner, he was instructed by one of his known, namely Kaku, to deliver computer system in the premises.
The learned counsel has submitted that the defense of the petitioner is that the petitioner was handed over the computers by co-accused
Co-accused in the college premises.
to deliver
Who is
the
in the
computer
business
systems.
Who is in the business of computers?
Yes,
And
and
the
the
petitioner,
co-accused is in the business of computers.
and this petitioner is a businessman having his own partnership firm in Jharkhand and provides manpower to various industries.
The petitioner is a businessman and is providing manpower to the with respect to computer
Manpower and labors to various industries and plants.
manpower and labor to various industries. After hearing the counsel for the petitioner and considering the serious nature of allegation
One thing.
against the petitioner and
Offense कुछ हुआ ही नहीं,
and
काम हुआ ही
होने के बाद आइएगा।
नहीं। अगर कोई क्राइम तो हुआ नहीं, अगर मान लीजिए ये मान भी लेंगे कि उन लोग कंप्यूटर चेंज, मेरे अगेंस्ट नहीं है कंप्यूटर चेंज करने का, ना कंप्यूटर चेंज करने का ना सॉफ्टवेयर। वो दो जो टीसीएस का एम्प्लॉय है जो एग्जाम कंडक्ट करता है वो और दिनेश
Just hold on. And the matter is still under investigation. This court is not inclined to enlarge the petition on guilt at this stage.
May I pray for you? Let it be posted after vacation or by that time charge.
ऐसा नहीं होगा ना। जिस स्टेज में आइएगा उसी स्टेज में केस डिसाइड करेंगे। यहाँ फाइल कर दीजिएगा, फिर हम वेट करेंगे चार्जशीट का। सुप्रीम कोर्ट बोलते हैं कि 15 दिन में बेल एप्लीकेशन डिसाइड कर दीजिए, कैसे करेंगे? हाँ, हमारा डेटा जाता है ना, हाई कोर्ट का डेटा जाता है कि 6 महीना तक बेल एप्लीकेशन नहीं डिसाइड। आप ही लोग जाते हैं। जिस स्टेज में रहेगा केस उसी स्टेज में केस में ऑर्डर। उसके बाद आप लोग को चॉइस है फाइल करने का कि चार्ज की एफआईआर के तुरंत बात करिए, कि चार्जशीट के बात करिए, कि चार्ज फ्रेम के बात करिए, कि विक्टिम के एविडेंस के बात करिए। दैट इज योर चॉइस, बट द केस विल बी डिसाइडेड एज ऑन द डेट।
इस केस में तो अगर
एक्चुअली बहुत सीरियस है मिस्टर, यू जस्ट अप्रिशिएट दिस।
ऑफेंस हैज नॉट बीन कमिटेड, चीटिंग क्या हुआ, कौन चीट? एग्जाम होता
अभी एट दिस स्टेज ही बोले ना, इन्वेस्टिगेशन का स्टेज है, होने दीजिए, फिर आइएगा उसके बाद केस डायरी देखेंगे, तब सोचेंगे क्या करना है। इसीलिए एट दिस स्टेज इन्वेस्टिगेशन हो सकता है, चार्जशीट नहीं हो आपके खिलाफ।
Item 10 DT.15.05.2026.
क्या चाहिए आपको?
आफ्टर वेकेशन अभी काउंटर रिसीव किया है।
काउंटर रिसीव पर आपको रिप्लाई देना है, भूल जाइए काउंटर। 183 का BNSS का स्टेटमेंट पढ़ो। यस,
डाइस हुए का एलिगेशन
हाँ,
डाइस हुए का एलिगेशन है तो उसके कवर्ड और लाइन भी है।
पूरा एलिगेशन है पढ़ना।
मेडिकल
मेडिकल के बिना कन्विक्शन नहीं होता है, ऐसा कैसे? विक्टिम का स्टेटमेंट बहुत रेलेवेंट है और आपके पड़ोस का ही है, तो इस स्टेज में आपको कैसे रिलीज करना? विक्टिम जब आपको देखेगी आस पास घूमते हुए, थोड़ा मुश्किल है ना,
वो पानी में वो बाहर में है
कॉम्प्रोमाइज हो गया।
अभी हुआ नहीं है वो आई
आप करिए कॉम्प्रोमाइज अपना देख के इसको, हम लोग के कोर्ट से तो नहीं होगा। इन्वेस्टिगेशन है स्टिल पेंडिंग। क्या हुआ उसके बाद? चार्जशीट हैज बीन सबमिटेड। विक्टिम का एज क्या है? पिटिशनर का एज 30 साल। कोई लव अफेयर का कहानी भी नहीं हो सकती। तो और सीरियस, रिलेटिव अगर विक्टिम के साथ ऐसा कर रहा है तो और ज्यादा सीरियस। टाइम बाद हो गया, कितना दिन का डिले?
घटना
मिसिंग का FIR है।
मिसिंग है
लड़की कहाँ से रिकवर हुई है?
लड़की बस स्टैंड से
Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner, who is 30 years of age, 31 years of age, has been falsely implicated in this case, and it has been alleged in the FIR that the victim, aged 15 years, was taken away by the petitioner on 29/7/2025, and the FIR regarding missing of the victim was filed on 1/8/2025. He submits that the petitioner happens to be the relative of the victim, and the victim was recovered from the bus stand. The charge sheet has already been submitted to the learned counsel for the state has opposed a prayer for bail. After hearing the learned counsel for the parties and considering the statement of the victim recorded under section 183 BNSS as received from the concerned court, there is direct allegation against the petitioner having committed the offence. In such circumstances, this court is not inclined to enlarge the petition until dismissed.
Item 11, DA 3694/2026.
The petitioner is in custody since 28th of June 24. Not a single witness has been there. Pursuant thereto, Lord was pleased to pass an order. The speaker in charge record was also called for. There's a copy of the record.
12 FIRs. How many FIRs have been registered?
It has come in the counter affidavit. Pursuant to information on the portal, 12 FIRs have been registered.
More than that, 12.
My submission is that I have disclosed that I have one more antecedent which is part of it. Apart from that, other FIRs which the state sees. These are of the year 2024. I am in custody since 24. No summon, not remanded in any case, no information till date. But the first time it is coming, it is not part of even the case diary. 2
You
years
must have investigated.
I could have been remanded in those cases. Someone should have been issued.
No. It has been registered. They will take the process out, isn't it?
It is of the year 24, they say.
Yes.
No new FIR.
You see, first they will find it out from the portal, and then they will find it out that these cases have been registered, and then they will write to them that you are in custody and you should be taken on remand. This is the process they are adopting. The complaints in the portal are 2020, 2021, 2022. It is there that a person has been defrauded. Those information is there. Cases are registered, but the point is that nobody is there. किसको पकड़ेंगे, किसको रिमांड पे लेंगे?
मेरा कहना है, the way they pull out the data from portal, it says that against this account number.
FIR का नंबर भी दिए क्या सर?
वही हम बोल मेरा submission है. अगर they say that these are 12 cases based on the account number, it is from the portal.
ये तो registered हुआ है ना केस?
वो based on account number बोल रहे हैं. So
नहीं ये केस का नंबर है, केस का नंबर. आप ये सबका सर्टिफाइड कॉपी निकाल के देख लीजिए आप एक्यूज्ड है कि नहीं.
हम क्या बोल रहे हैं कि इनका स्टेटमेंट है लॉर्ड में सी देयर काउंटरफिट पैरा 12. It is not against the petitioner, against the account number. They said this account number is mine.
It is not your account number.
They say as per allegation it is mine.
It is not your account.
It is my account.
Then
I say that my account was misused. So to consider those cases as to be my antecedent, it could be subsequent act post-incident, and as on date, I have not been issued notice in any case. These are all cases out of Jharkhand. It will be
no.
It
is in Ranchi also. Ranchi PS, Ranchi PS, Ranchi PS, 1, 2, 3.
3 केस में सेमी केस का रिपीटिशन है 2 और 3 और एक केस है जो हमने पिटीशन में लिखा है that I have one antecedent I have disclosed. Apart from that, all other cases are from different states. So it is impossible for me to get those data, and I have not been remanded, no notice, no summon in any of the cases. तो इनके पास अकाउंट का डेटा पुल करके हमको केस बना सकते हैं, तो मेरा भी डेटा पुल करके they can see that I am in custody.
एक बात बोले कि मेरे अकाउंट को मिसयूज किया.
हाँ,
जो अकाउंट नंबर ऑपरेट जिस मोबाइल नंबर से हो रहा था वो अकाउंट मोबाइल नंबर इनके पास से सीख गया. एक बार बोले कि हमारा अकाउंट मिसयूज किया जा रहा है, इनका अकाउंट
आपका ये रिपीटेड मिसयूज होता जा रहा है.
नहीं, हम तो रांची वाले केस में I'm saying that for there are 2 cases we have disclosed my petition. With regard to other cases it is for the very first time it is come. और कल ही शाम को काउंटर एफिडेविट मिला है मुझे. I am not in a position to seek instruction with regard to this, but I have got information from that regard that there are no instruction or information with regard to
इंफॉर्मेशन नहीं होगा ना, अब हो जाएगा. आपने रिमांड पे नहीं किया है.
किसी के
हिमाचल में लेटर लिखे होंगे और फिर गाड़ी में
रांची वाले केसेस में तो नहीं होंगे ना, 3 केस दिखा रहा है.
रोड पर पूरा इंटायर ऑर्डर शीट देख लीजिए तो किसी में कुछ नहीं है.
ये कॉरेस्पोंडेंस करते हैं जहां का केस था.
आपका केस ऑन मेरिट्स अर्लियर रिजेक्टेड है ना?
Rejected for 2 years, not a single witness has been examined.
9 lakh rupees is directly transferred in the account of this petitioner.
Page 30 is the earlier order.
और वो अकाउंट जिस मोबाइल से ऑपरेट हो रहा था वो मोबाइल इनके पास से सीख गया.
क्या रीजन है कोई विटनेस नहीं एग्जामिन करने की?
ये तो रिपोर्ट नहीं.
For that matter,
रिपोर्ट नहीं है मतलब ये कौन बताएगा? आप कस्टडी में रखेंगे और किसी को एग्जामिन नहीं करेंगे, ऐसा कैसे चलेगा? बाकी सारे केसेस हैं जो चूंकि अलग अलग केस इंस्टीट्यूट हो गए हैं, अलग अलग केस में रिमांड होगा, इनका ट्रायल होगा. लेकिन इस केस में आप क्यों नहीं प्रोड्यूस करते?
विदाउट वेरीफाई इंस्ट्रक्शन ये नहीं बता पाएंगे कि क्यों नहीं। एक्चुअली जो
ये तो लास्ट ऑर्डर हुआ था ना?
रिपोर्ट हुआ।
लास्ट ऑर्डर हुआ? केस रिकॉर्ड आया है इनका ऑर्डर शीट? नहीं आया ऑर्डर शीट। ऑर्डर शीट नहीं आया। Receive and get ये आप लोग क्यों नहीं प्रोड्यूस करते? ऑर्डर शीट बनाया होगा, साथ में मिला होगा। Yes. There is no explanation as to why have you not produced any pieces. Instruction तो लेना, ऑर्डर शीट दिख रहा है। हाँ, नॉन बिलेबल वारंट वगैरह सब होता है। कल तो देख ही नहीं है हम लोग सारा इंस्ट्रक्शन का कहानी। Who is the IO in this case? कहाँ का केस है ये?
रांची का केस
There are only 4 charge sheet witnesses.
One became three official.
Natural to do this, what are you doing?
इंस्ट्रक्शन ले लेते हैं क्या क्या किया। तो ज़्यादा डॉक्यूमेंट्री एविडेंस है।
Or the learned counsel is appealing on behalf of the parties. The order sheet from the concerned court has been received, which reveals that after the bail application of the petitioner was rejected earlier on.
Main petition dated 24th of February 25.
On 24th of April 2025.
February.
On 24th of February 2025. No witness has been examined. It further appears that the charge was framed on
7/10/2024.
7/10/2024, and learned APP was directed to produce evidence on the next date. And on repeated occasions, not even single witness was produced, and the petitioner is in custody
28/6/2024.
since 28/6. The learned counsel for the state had submitted that a counter affidavit has been filed, but there is no explanation with regard to non-production of witnesses. However, he has submitted that as per the counter affidavit, the petitioner is engaged in mass-scale cyber fraud, and the phone to which the cyber fraud has been committed is related to his bank account, and numerous transactions have been reported. As many as 1,111. कितना है total? How many instances?
118.
Numerous cases of cyber fraud has been reported. And the petitioner in his confession statement has also stated that a total of 4 crore 80 lakhs rupees transaction took place in Dilkhush Enterprises HDFC bank account, in which the petitioner is a proprietor. In which the petitioner is a proprietor. It has been further stated in the counter affidavit that in the portal as many as 12 FIRs has been registered. From different locations, and 3 are from Ranchi.
There it is repeated. Second and third is repetition.
Sorry?
Second and third cases.
Okay, there are 2 cases from Ranchi. To this, the learned counsel for the petitioner has submitted that so far as second case from Ranchi is concerned, he has stated that he has a criminal antecedent.
Yes, repetition.
But so far as the other cases registered in different locations, in different states, the petitioner has not been remanded so far.
And also there is no information I can receive on the IO or notice in connection with those cases.
It has been also stated in the counter affidavit that in the account of the petitioner, 93 cyber fraud complaints have been registered, and out of 93 complaints, 12 formal FIRs has been registered. However, the counsel for the state has submitted that the next date in the trial is 24/2026 and 20 March, and the deposition of the witnesses will be recorded without any further delay. And as per the charge sheet, there are only 4 witnesses. After hearing the learned counsel for the parties, this court is there is no proper explanation coming from the side of the state as to why in such a serious case the witnesses are not being produced. and the petitioner is trying to, the petitioner is in custody without trial. However, considering the serious nature of allegation against the petitioner dealing with large cyber fraud racket, and the statement made in the counter affidavit showing readiness and willingness to produce the witnesses right from 25/2026. This court is not inclined to enlarge the petitioner on bail. However, if the witnesses are not produced in spite of this order, the petitioner may renew his prayer for bail after 6 months. 6 महीना में अगर witness नहीं produce होता है, the state is directed to ensure that the witnesses are produced without fail on every date, as may be fixed by the court. The counsel for the state is directed to communicate this order to the SP of the concerned district and also to the director of prosecution.
Maximum punishment in 467 now that we travel on
6 महीना वेट करिए, बहुत सीरियस है. 6 महीना में नहीं होगा, I guarantee you right now I will give you. If they do not produce the witness, victim नहीं आएगा, बैंक अकाउंट नहीं एग्जिबिट होगा, तो इसे बहुत मुश्किल है. आपको लग रहा है ये लोग कर लेंगे? लगता तो नहीं है.
Item 12, BA 3717 of 2026.
FIR under section 1 bracket 1 115 bracket 2 172 charge sheet submitted 103 bracket 1 to 38. लॉसिप मेरे को कोई भी के साथ मिलकर डेट बोले तो छिपाने का सर्टिफिकेशन.
Is that so?
Them transcribed all the some of the main Rameswar.
एक बात बताइए,
After murder,
कस्टडी कब से है?
11/11/25.
Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that name of the petitioner has transpired in the confession statement of co-accused, and the only allegation against the petitioner is that he had assisted in hiding the dead body. How are you related to the victim? How are you related to the victim? आप कौन है victim?
victim कुछ भी नहीं.
दोस्त, मेरा दोस्त
पहले नहीं है.
in diary it is stated that मेरा दोस्त मधुसूदन को गाड़ी को लेके हम person है. मेरा दोस्त मधुसूदन कांडियो मधुसूदन मेरे घर आया हुआ था. उस दिन मेरे घर में सोया हुआ था. उसने इतना सारी बात बताई. लाश को छिपाने में मदद करने के लिए बोला. उसके बाद मधुसूदन मेरा मदद करने के लिए लगा.
The learned counsel has submitted that the petitioner is in custody since 1/11/2025. The learned counsel for the state has opposed a prayer for bail. However, the aforesaid submissions are not in dispute with respect to the role of the petitioner. Considering the aforesaid submissions and the custody of the petitioner is admitted to be
From date list, corpus filing item 1, BA3793 of 2026.
Case of cybercrime. Earlier one case was registered against the petitioner. He has been acquitted in that case. So in the order of acquittal. Now, serial number 1 and serial number 29 has been almost same.
Sorry.
Serial number 1 and serial number 29
29 का भी फाइल है.
has been almost same. One mobile phone with one SIM was recovered from position. There are
One mobile, one SIM.
one SIM.
How many victims?
There are 2 victims, madam,
2 victims.
and a charge sheet has been submitted 17 to 2026 and custody.
और the what do you say? इन्होंने सही बोला गलत बोला? Heard the learned counsel submitting on behalf of the parties. The learned counsel for the petition submits that, as per the counter affidavit, the petitioner has one criminal antecedent, but he has been acquitted in the same case. He has filed a supplementary affidavit before this court, annexing the order of acquittal. He submits that the petitioner has been, in the present case, has been alleged to be apprehended with one mobile, one SIM, and he is in custody since 17/12/2026. Charge sheet has been submitted and 2 victims have been identified. The learned counsel for the state has opposed the prayer for bail. However, the posted submissions settlement है ये. Acquittal नहीं है.
Compoundable offense, that's it.
But
That is the reason.
लेकिन आप इसको acquittal नहीं बोल सकते.
I am acquitted of
Acquittal थोड़ी होता है.
acquitted of
Acquitted of जब आप कंपाउंड करिए तो सबसे पहला बात ऑफेंस एडमिट किए. The moment you compound, the first is admission of offense. Yes, isn't it? गलत है. एक्यूटल और कंपाउंडिंग में फर्क है ना, बहुत फर्क है. आप मोटर व्हीकल में जाके कंपाउंड कर लीजिए तो दूसरे कंट्री में तो 3 बार ऑफेंस होने के बाद लाइसेंस ही खत्म हो जाता है. इसीलिए लोग कंपाउंड नहीं करते. इतना आसान, इतना हल्का चीज नहीं है कंपाउंडिंग. कंपाउंडिंग इज एडमिशन ऑफ गिल्ट. और मैडम आप क्या बोल रही हैं? एक्यूटल. हम आपकी बात हमारे कान तक नहीं पहुंची. After hearing the learned counsel for the parties, it appears from the supplementary affidavit that the offence
discharge of securities and discharge of securities.
तो क्या हो? इससे क्या हो?
I am discharged. आप उसमें वो केस मेरा against
नहीं है ना, बट आप तो कंपाउंड करिए.
It is against 3 accused persons, not against me. And 420 is compoundable in law. That is, no other IT Act was not.
आप समझ नहीं रहे. कंपाउंडेबल है,
I understood.
but that is not acquittal. Okay. After hearing the learned counsel for the parties, this court finds that, as per Annexure A to the counter affidavit, one case was instituted under Section 420/120B of IPC, which the petitioner has compounded. But certainly the case was not registered under the cybercrime. Right? Considering the appropriate facts and circumstances and the fact that the petitioner is in custody since 17/26 and charge has already been framed,
Charge sheet, please.
charge sheet has been submitted, the petitioner is directed to be embarked.
29.
Sorry?
Serial number 29.
29 में भी ये कंपाउंडिंग है.
नहीं 29 में कोई antecedent नहीं. कोई antecedent नहीं, उसमें भी 2 victim है बस.
सीरियल नंबर
Item 29.
29.
BA3000.
2 victims.
हाँ, 2 victims.
How many mobile?
One mobile phone with
One mobile,
with one SIM.
one SIM. Custody?
Same custody 17 to 2026.
No antecedent?
No antecedent.
No antecedent? Heard the learned counsel's opinion on behalf of the parties. The learned counsel for the petitioner submits that the petitioner having no criminal antecedent is in custody since 17 to 2026. He submits that one mobile, one SIM is alleged to have been recovered from the possession of the petitioner and two victims are said to have been identified. Charge sheet has already been submitted. The learned counsel for the state has opposed a prayer but does not dispute their future submissions. Considering the fact that the charge sheet has been submitted and the petitioner has no criminal antecedent, the petition is eligible to national.
Item 2, BA 3797 of 2026.
One mobile, one SIM. SIM stands in the name of petitioner. No victim by law. Charge sheet has been submitted to one SIM.
One mobile,
With
one
SIM.
custody 14 to 26.
26 charge sheet has been submitted on 4/5/2026.
No antecedent.
No antecedent.
Correct. The learned counsel for the petitioner submits that the petitioner is in custody since 14 to 2026, having no criminal antecedent. He submits that it is alleged that one mobile, one SIM has been recovered from the possession of the petitioner.
Since in name of
मेरे नाम पे है कंटिन्यू
हम कहाँ लिखते हैं किसके नाम से?
सॉरी नहीं
मोबाइल के आपके नाम से?
हाँ मोबाइल है
Which are in the name of the petitioner and no victim has been identified and charge sheet has been submitted. The learned counsel for the state has opposed a prayer for bail but does not dispute the alleged submissions made by the counsel for the petitioner. Considering the fact that the petitioner has no criminal antecedent and the charge sheet has already been submitted, the petitioner is eligible to be national.
Item 3, BA 3903 of 2026.
327 and 28 arising out of the same. There is
327 and 28.
one mobile, three SIM, one mobile and two
Just a
SIM.
moment. One mobile,
Two SIM,
two SIM,
three SIM,
three SIM.
One, the mobile and the two SIM belongs to the petitioner. Another SIM is another name. No victim, no criminal antecedent. Charge sheet has been submitted.
You are in custody since?
21 to 26.
The submissions are correct. Or the learned counsel is appearing on behalf of the parties. The counsel for the petition submits that the petitioner is in custody since 21 to 2026, having no criminal antecedent. He submits that one mobile, three SIMs are alleged to have been recovered from the possession of the petitioner, but no victim has been identified. Charge sheet has already been submitted. The counsel for the state has opposed a prayer for bail, but the aforesaid submissions made by the petitioner are not in dispute. Considering the aforesaid, considering the fact that the charge sheet has already been submitted and the petitioner has no criminal antecedent, the petitioner is eligible to be enlarged on bail.
There is recovery of two mobile, two SIM. Out of that, one mobile, one SIM belongs to the petitioner. No
Just a
criminal.
moment, just a moment. Two mobile,
Two SIM.
two SIM,
One mobile, one SIM belongs to the petitioner.
not required.
There is two victim lot of 20,000 and 29,000. No criminal antecedent
No antecedent.
and charge sheet.
Custody consent.
ये किस changes?
इसका सेम ऑर्डर है टू मोबाइल टू सिम टू विक्टिम्स ठीक है नो एंटीसीडेंट कस्टडी सिंस 21 to 26 चार्ज शीट हैज बीन सबमिटेड
39 complaint being the link.
The learned counsel for the state has opposed a prayer for bail and has submitted that but does not dispute the aforesaid submissions. However, he submits that 9 crime links 39 crime links
Yes. Then you decide para 55.
ये 39 क्राइम लिंक्स में कोई एफआईआर इंस्टीट्यूट हुआ है या आपने इंक्वायरी नहीं की
Yeah.
नहीं है
FIR का inquiry.
Inquiry नहीं, investigation is on.
और नो कंप्लीटेड चार्जशीट
Investigation is पूरे crime का खत्म हो गया है.
पूरा का अनुसंधान
जारी है, पूरा अनुसंधान जारी है.
The counsel for the petitioner has submitted that 2 mobile, 2 SIM have been recovered from the possession of the petitioner and 2 victims have been identified. And he is in custody since 21 to 26 and charge sheet has already been submitted. The learned counsel for the state has opposed the prayer for bail and has submitted that 39 complaints of cyber fraud has been found in JMIS/14C portal against the mobiles SIM found and seized from the possession of the petitioner, and investigation is still going on. And so far, there is nothing in the case diary to indicate as to whether FIR has been lodged in connection with the 39 complaints. Submits that necessary inquiry will be done in near future. Considering the numerous complaints lodged in the portal against the petitioner, this court is not inclined to enlarge the petitioner on bail at this stage. At this stage,
But कोई complaint FIR में चार्जशीट there is no FIR it has come.
थोड़े दिन बाद आइए फिर से देखिए. At this stage ही कर. तब तक ये 39 कंप्लीट का काम
विड्रॉ कर लेते हैं एंटी विद द लिबर्टी टू रिमूव अगर कुछ आता है फिर
आप इसका इंक्वायरी करिए भाई. आप लोग इस तरह का इन्वेस्टिगेशन डिफेक्टिव नहीं रख सकते. एंड दिस पर्सन का बहुत ज्यादा केसेस है. आई हैव सीन.
नहीं ये आदमी का नहीं है कोई
नाम तो यही है, हो सकता है एक ही नाम का चार
नाम
आदमी.
बहुत डिसिम्बलेंस होता है बट दिस पिटिशनर हैज नो फादर इज द गिवन नॉन
कोई
नो
बात.
क्रिमिनल
आप थोड़ा वेट करिए. एट दिस स्टेज ही किया है.
यस विड्रॉ कर लेते हैं.
नहीं रुको. आप दोबारा आइएगा. यही 39 कंप्लेंट्स का अगर इंक्वायरी में कुछ नहीं आया हम आपको
तो ये दे हैव सबमिटेड चार्जशीट ट्रायल
तो क्या चार्जशीट करने से क्या हो गया?
तो
इन्वेस्टिगेशन इज स्टिल गोइंग ऑन. कुछ फर्दर नहीं आ सकता है ट्रायल में.
मतलब एक टाइम दे दिया जाए इतना दिन के बाद हम आ जाते हैं यही
आप आइए. आप आइए खुद से आइए ना. हमारे टाइम देने से हम आपको 6 महीना भी क्यों रोकें?
नहीं ठीक है
ठीक है.
हम कुछ दिन के बाद
आप कुछ दिन के बाद आइए. तो उसके बाद ये लोग ये काम ही नहीं करते हैं तो हो जाए.
नेक्स्ट केस
इसीलिए
नेक्स्ट केस में कोई क्राइम लिंक भी नहीं है. नो क्रिमिनल इंसिडेंट. वन मोबाइल फादर्स के नाम पर है. नो विक्टिम.
वन मोबाइल
वन सिम इन द
One
नेम
SIM.
ऑफ फादर.
ओके. नो विक्टिम.
नो विक्टिम. नो क्राइम लिंक आल्सो.
आप बताएं. कस्टडी
वो सेम डेट है 21
or the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 21 to 2026, having no criminal antecedent. It submits that one mobile, one SIM, which is standing in the name of his father, has been seized, and no victim has been identified. Charge sheet has been submitted. The learned counsel for the state has opposed a prayer for bail, but does not dispute their opposite submissions. Considering the opposite submissions, the petitioner having no criminal antecedent and charge sheet having been submitted, the petitioner is directed to be enlarged on bail.
Item 4, BA 4021 of 2026.
I don't know. पास ओवर है बहुत मुश्किल है. आपके अनुसार टाइम नहीं होता. देखिए अगर पासओवर हो सकता है तो।
After petition,
At the request of the counsel for the petitioner, post this case
Appeal
on
rejected.
किसका कहाँ से रिजेक्ट
I think parallel by this
What do you want?
I need a copy of channel how stage have been changed.
Stage has changed.
Yes, because time will be matching because
The bail application of the petitioner was rejected earlier by this court. The counsel for the petitioner seeks adjournment. कौन सा डेट आपको शुभ दिन कौन सा
I need to explain after petition.
पोस्ट ऑन 16th of June. लोग पूजा पाठ करते भी आते हैं किसी में देखते हैं थोड़ा हल्दी वल्दी लगा रहता है इंसान होता है किसी से फाइंड
Item 5, BA 4161 of 2025.
Yes, please.
May I please?
26.
Offenses are under section 66 of BNS code. Result is 376. So the FIR is at page number 10. The relevant part is at page number 10. The allegation is that the informant, who happens to be the son of the deceased, has been informed that his mother, along with the petitioner, went to the mountain to drink wine. While coming back, the person who saw has informed the informant that the petitioner has been committing rape upon him. Because the occurrence has happened on 28/8/2025. It is stated in the FIR. दिनांक 28/8/2025. Admitted in the last 5 lines from the bottom. आज दिनांक 30/8/25. He was informed on 28th about the occurrence, but he went to search for his mother on 30th. That is after 2 days. आज दिनांक 30/8 को समय करीब 10 बजे सुबह जंगल तरफ गए तो देखे गंदा तो तुरंत जंगल पर गए तो देखा कि मेरी माँ का लाश पड़ा। Nothing has been recovered from the petitioner. The sole evidence is the confession of the petitioner. I am in custody from 31/8/2025, 8/115 days. No criminal antecedent. Charge sheet has been submitted. As per the e-court services, I have claimed the charge. Next date of charge is on 5/6/2026.
He is an eyewitness to the occurrence of rape. He is an accurate
He is an eyewitness. He has informed the informant on 28th itself. But he went to search for his mother on 30th. That is after 2 days. दिनांक 28/8/25 को समय करीब 3 बजे शाम को देखना चंद्री पहाड़ी मूल करीब 1600 एवं अरनी पहाड़ी पति 1600 सुकू पहाड़ी is a petitioner जिला साहिबपुर सुकू पहाड़िया थाना दारू पीने पहाड़पुर गांव गए थे। वहां दारू पीकर चांदी पहाड़ी एवं अरनी पहाड़ी दोनों आ गई। समय करीब 4 बजे मेरी माँ एवं सुकू पहाड़िया आ रहा था। समय करीब 5 बजे अरनी पहाड़ी ने देखा कि मेरी माँ के साथ सुकू पहाड़िया गलत काम कर रहा था। ये जंगल जड़ी बूटी खोजने गई थी। इन्होंने तुरंत आकर बताया। तब से हम खोजबीन की शुरू की। साड़ी खाड़ी होने के कारण नहीं मिली। आज दिनांक 30/8 को समय करीब 10 बजे जंगल तरफ गए तो गंध आया तो तुरंत माँ को
क्या बोलना है?
But she's eyewitness of the rape. Dharmi Pahari. He is stated madam.
पोस्टमार्टम में क्या है?
Postmortem described is a team player. As per the inquest, madam गला दबाकर हत्या करने का उनके एप्लीकेशन है. He also accepted the confession. Madam, the confession has been recorded. He narrated the same story.
That is the only evidence. Madam, let's see the improved order.
Dharmi Pahari, madam, may I read the
Page number 25, last page.
इस कांड के साथ धर्मी पहाड़ी को फलना बिहार पहाड़ साहिबगंज के निवासियों समझ के बयान दिया। उन्होंने अपने बयान में बताया कि दिनांक 28/8 को वो अपने बीमार बेटे के लिए दवाई लाने पहाड़ की तरफ गई थी। उस समय करीब 5 बजे उसे सुकू पहाड़िया पिता सचिन सच साहिबगंज में ग्राम बिहार पहाड़ के माड़े कोटा पहाड़ की तराई में वादी की माँ चंदू पहाड़ी नाम डिजिटल मैडम के साथ गलत काम करते देखा, परंतु वह डर की वजह से बात किसी को नहीं बताई थी। मुझे पूरा यकीन है कि वासु पहाड़िया की माता चंदू पहाड़ी को सुकू पहाड़िया की जिसमें मैडम वो विदेशी पहाड़िया ने साइलेंट बलात्कार करने के बाद उसकी हत्या कर दिया है और शव को छुपाने का शव को झाड़ी के अंदर फेंक दिया है। साची धनु पहाड़ी के बयान के वीडियो के साथ अपलोड किया गया साइड में।
That is an improvement from the FIR. Madam, the FIR ऐसा कुछ है नहीं कि झाड़ी में छुपा दिया गया है.
Thereafter, place of offense, first place of offense, he was indicted by the IU madam. ये थाना का हेड किला सारा बताया कि घटनास्थल पर पहुंचे था। ग्रामीण के बताए अनुसार कांड के घटनास्थल में बलात्कार करने हत्या करने के बाद सीसी का निशान किया। प्लेस ऑफ फर्स्ट प्लेस ऑफ ऑफिस मैडम। उसके बाद सेकंड है जो कांड का घटना जहां पर होगा का पेड़ नीचे गला दबाकर हत्या करने के बाद प्राथमिक दृष्टि को पहाड़ी बताई गई। ग्रामीण सब सेकंड मैडम फिर था स्थान पर प्राथमिक दृष्टि को पहाड़िया eyewitness of the
Eyewitness of the occurrence, but it may not be necessarily rape. It may not be rape because she was not protesting. The informant did not protest, and then she was found dead. Informant is the son.
Madam, sir, one more thing, madam. The informant has stated that he has seen the place where the occurrence was happening. What stopped from the informant to go and find out on the 20th itself? He says that we have recovered the body on the 30th after 2 days.
The informant did not see the victim protesting. He did not see. That is not the allegation.
What is the government party told by the ऐसा करते हुए देखा।
Last scene हुआ ना उनके साथ?
हाँ, उनको last
scene हुआ that they were found in that position. All relations are not rape.
There is a reputed position that they have gone to drink together to the mountain.
Confession के अलावा कुछ नहीं है। Custody कब से है? 28 आठ।
That's 31/8/2024. 8 months 15 days after.
For the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner says that, as per the FIR itself, the son of the victim, which has been lodged by the son of the victim, the petitioner and his mother had gone together for consuming alcohol, and he had seen the petitioner committing wrong against the victim. Yes.
The informant has been informed by some other person. The informant has not seen the occurrence.
Informant has not seen. Yes. Informant कौन है? The
In the beta.
But the informant is also hearsay.
Yes, madam. He himself states in the FIR itself that हमको बताया चरनी पहाड़ी की वहाँ देखे
Okay, okay. The This the learned counsel for the petition submits that the FIR itself has been lodged on information received from another person, wherein it is alleged that the person had seen the victim uh, that the petitioner and his mother had gone together to consume alcohol, and the said person had seen the petitioner committing wrong against the victim. This happened on 28/8/2025, and thereafter the victim had returned home. Victim आ गई थी ना घर, नहीं आई. And thereafter she was missing, and ultimately the case was filed on 30/8/2025, when the petitioner saw the dead body of his mother in Jammu. The learned counsel for the petitioner submits that, except confessional statement of the petitioner, there is nothing against the petitioner, and he is in custody since 28/8/2025. Sorry, 31/8/2025. The learned counsel for the state has opposed the prayer and has submitted that
Field of this petition.
and has submitted that the petitioner has committed rape upon the victim, and the dead body was found in the forest. Forest में भी order में भी लिखा forest. And that the informant claimed that the petitioner had raped and strangulated her mother. Postmortem report आया इसका? Postmortem नहीं है आपके पास? नहीं है? है? During the course of hearing, the learned counsel for the state has produced a postmortem report and has submitted that the cause of death could not be ascertained. And some sample has been sent to FSM Ranchi. Considering the aforesaid facts and circumstances, and that the petitioner has been primarily made accused on confession statement, and nothing is, so far as the murder of the victim is concerned, and the cause of death could not be ascertained from the postmortem report, The petitioner being in custody since 31/8/2025 is directed to be enlarged on bail.
Item 6 BA 4163 of 2026.
Actually, under 302, first time listed sole responsibility. Actually, the informant is the father of the deceased who got an information from the granddaughter actually from telephone that the mother of the granddaughter, who is the daughter of the informant, found dead in her matrimonial house worship. And also that a day before there was a dispute between the husband and the wife, and thereafter this FIR was lodged. May I read, Lodge?
The learned counsel for the state is directed to file a counter affidavit in this case that the case diary be called for from the concerned court, along with the postmortem reports of the victim. The state is also directed to serve notice upon the informant of the case. Post on 16th of June.
Item 7 BA 1498 of 2026.
The previous occasions when the matter was heard, then his honorable court has been pleased to prepare a report with regard to the forensic sciences laboratory report concerning the WhatsApp details and from the mobile of the petitioner accused. That was on 15/4/26, order number 4. And since it was not received, so on the last date 6/5/2026, again for that purpose the matter was adjourned. And apart from that, the 164 statement, that is 183 BNS statement of the victim was also called for. And the status stage of the trial was also called for.
Forensic report has come. Forensic report has come.
The learned entity has not filed any, and if it is received in sealed cover, it will be before the honorable court, then it will
Are you for it?
be closed. He represents the
You
informant.
are the informant. Earlier rejected.
No, present.
Fazan Ansari.
Yes. It's a press matter. The offence is 64(2)(m) and 351(2) of the BNS. It is based on a written report of the victim.
What is the age of the victim?
19 years, admittedly. Page 21, she herself says 19 years. And there is delay of 3 months in so far as the last offence, date of the last offence is concerned. That is mentioned as 26/5/2025. And his written report has been lodged in the month of August, 27th August. That is after 3 months. Without any, there is no explanation in formal column 9 of the FIR as to what is the reason of the delay. And that creates a doubt with regard to, because so far the allegations are concerned, the first line she herself admits that she became friendly to this petitioner through Instagram. And thereafter the
कुछ
further
भी रिकवरी हुआ कोई फोटो का कहीं से कोई रिकवरी हुआ
because the chances
इंस्टाग्राम
of-
का इतना कहानी सुना है कोई तो वीडियो रिकवर होना चाहिए ना कैसे सिक्योर करेंगे कन्विक्शन फोन सीज किए कुछ किए क्या किया फोटो वायरल का यही भेजा है आईटी में
हाँ. Because when this petitioner was arrested from railway station while he was going to Dhanbad, then the mobiles which he had with him were seized. And further, the charges have been framed. Last 5 dates, there is no witness has been produced by the prosecution. We have brought it on record while we have supplementary evidence. And the allegations in itself, it does not, in toto, if it is assumed to be true, in toto it does not appear that the offences has been committed so far as 64(2)(m) or 355 is concerned, because she is a major girl and she admits that she became friendly through Instagram, and then she makes further allegation, and both allegations On the one hand, she says
You were
that
absconding.
no, he is in custody since 9/10/2025. The case is of August 25.
प्राथमिकी अभियुक्त
9/10/25.
9/10.
9th of October. And this FIR was registered on 27th August 25. And the so far as the petitioner is concerned, his father is swearing the affidavit supporting this bail application. He also undertakes in the event of, because the prayer in for bail, he has to ultimately face the trial if at all the prosecution is able to secure his conviction. Even the charge sheet was submitted, it mentions that without the, although medical report may not have relevance after such delay, and without the FSL report, nothing is there. And then, in the first information report itself, the informant refers to two previous cases of the petitioner. The said previous cases of the petitioner lodged, both the cases were lodged, one case by a daughter and the other case by the said daughter's father. Both cases, and in both the cases, this petitioner is on bail. In one case, he has been granted anticipatory bail by this honorable court, another case regular bail by this court.
Your Honor, in the instant case, there is a specific allegation to we established the relationship, recorded some obscene photograph, and on pretense of deleting the same, he called me in the hotel, and again established forceful physical relationship with me also. This fact has also been coming to during the investigation that I was called into the hotel, and there are independent witnesses have also similar nature of cases. He is accused in other cases also. और उसमें भी इसी तरह से फेसबुक में बच्चे लोग के साथ ये करके उसको ब्लैकमेल किए हैं. Although they are aware, and as far as trial is concerned, as per my information is concerned, today आज गवाही victim की भी हो गई है और 3 या 4 witnesses की भी है आज.
4 विटनेस की आज गवाही हो गई.
जहाँ तक हमको पता है हम नहीं कर सकते हैं कौन से यहाँ कोई
और
ये जो है this petitioner is having criminal accident of same nature और इसी तरह का एक जो है
और
जो है निकलना इस केस के लिए बाकी लोग के लिए भी इसी तरह के इनका
नहीं दे रहे शांति रहे.
Very answers.
Repeat offense इस तरह के repeat offense.
So far as the if this honorable court
आपका ट्रायल एक्सपीडाइट करा दो. 4 विटनेस आज हो गया. कितने विटनेस हैं?
So I have no information. We have brought on record.
How many witnesses are there?
9 charge-sheeted witnesses are there. And only one thing. So far as if this honorable court is considering the antecedents, the cases, one case lodged by a victim, the other case by her mother, both the cases. With that case also victim measure, and then the same victim's mother filed, and this victim is also of the same place, and in both the cases, till now there is no conviction, therefore he has been granted in one case anticipatory bail and another case regular bail.
That's it.
I am only praying.
I have heard you. I will record everything. Don't worry.
I was only saying that this was a case. This was a case where it appears that the offence has not been committed. I may not be correct to say that it is a consent, but it appears to be a case of consent.
Consent तो था, लेकिन वीडियो बनाने के लिए नहीं.
That there is no evidence on that. Therefore, if lordship kindly
सब का पेन ड्राइव वगैरह सब है.
का exhibit कुछ भी नहीं है.
आ जाएगा ना.
और चार्जशीट जो सबमिट हुआ है,
अगर नहीं आएगा तो आपका एक्यूटल हो जाएगा. बाकी आपका 4 विटनेस हो गया है, 5 विटनेस और हो जाएगा.
Ultimately, he is a young boy. He is lying behind the bar for last 8-9 months, and he was in job. He has got a technical qualification that we have brought NCBT, and then he was on a job and he has lost the job because of this. And his father undertakes to be a bailer in such situation. On such conditions that he will physically appear on each and every date, if this honorable court thinks proper, that conditions may also be imposed by putting his father as a surety and then
Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case. As per the allegation, the victim became friendly to the petitioner through Instagram, and the petitioner established consensual relationship. The petitioner established a relationship with the physical relationship with the victim. It was captured in video, etc. And then the petitioner started blackmailing her that her video would become viral, and subsequently she was further abused sexually. The learned counsel for the petitioner has further submitted that the FSL report has not yet come. The counsel for the opposite party has opposed the prayer for bail and has submitted that there are similar cases lodged against the petitioner, two similar cases lodged against the petitioner, and the allegations are very serious. The counsel for the state has submitted that the video, etc., has been collected in pen drive and has gone for FSL, but so far FSL report has not been received. With this, the counsel for the petitioner submits that out of the two cases which has been registered against the petitioner, in one he has been granted anticipatory bail, and in the other he is on bail.
And one more thing we added from the side that both the cases are not of similar nature. It does not.
And both the cases are not of similar nature. This case, this section may.
One is of 354 and
one case is under section.
and 354.
Just a moment, हाँ बताइए.
सिमिलर है लॉर्डशिप
दोनों का एफआईआर लगा हुआ है.
2020 में एक केस हुआ, उसके बाद उससे रिलीज होकर 2022 में किए. दोनों में 67 आईटी एक्ट लगा हुआ है.
दोनों का एफआईआर कीजिए. दोनों का एफआईआर रिकॉर्ड में है.
कोई बात नहीं.
दोनों के एफआईआर रिकॉर्ड में 354.
Just that is enough. After hearing the learned counsel for the parties and considering the serious nature of allegation made against the petitioner, and the petitioner also has criminal antecedents, the victim has supported the allegation made and in the statement recorded under section 183 Genesis. This court is not inclined to enlarge the petition on bail. Accordingly, the bail application is rejected.
Item 8 DA.15.07 of 2026.
And we have a day for it.
Not served, how do I know that you are served?
Notice.
Notice language. Sir, on the family of the victim, as the federation of the
ठीक है बात है. The learned counsel
हम
for
अभी
the
आज
parties
ही
are
कॉपी
present.
इनको दे दें.
The counsel for the informant appears.
not informative.
Victim.
The counsel for the victim is present in the court. He submits that a copy of the bail application will be provided to him. The counsel for the petitioner undertakes to provide a copy of the bail application to the learned counsel for the opposite party, private opposite party. Let this case be posted on 8th of June. 8 June. 8 June.
Yes.
Thank you.
Item 9 DA.24.23 of 2026 along with item 10.
The 3 antecedents, probably extra 3 antecedents they forgot to mention. So we have given us today itself.
You've got the information about all the antecedents.
So I have one information of 2. One, I have listed out. Apart from the state had given, in found out I have another antecedent which I wanted to put on record that I have prepared an affidavit. My learned friend has added 2 more.
which are complaint cases which I had no idea. That's why I could not. He says not to take
One,
that.
one which he had not mentioned, today we have mentioned it.
And I
So
was
in counter
छुट्टी के बाद करें
Huh?
इस सब को
छुट्टी के बाद करें
And he said
So far, the other cases.
other cases were there less assessments.
सब छुट्टी
सब छुट्टी के बाद
So far,
हो
our
सकता है आप लोग की किस्मत में कुछ बढ़िया
हाँ
हो
हाँ हाँ
जो client का case.
वो आप लोग मतलब when you are bearing the ground and addressing the client.
This may take some time.
This will take some time, and there are other cases on board. That is why. Otherwise,
So if I have it
you can have it on line
हाँ, sure sure.
with the consent of the land council for the parties post this date on line. आपको जो भी कुछ करना है अपना वही कर लीजिएगा. Antecedent इतना सारा.
we have filed.
Item 12, BA 2464 of 2026.
all are
ये भी इसी से है ना?
हाँ सब उसी से
Item
उसी से
Tied up है ये.
सब सब हाँ सब
सब tied up.
सब
With कर दीजिए.
well
नहीं.
This is 12.
11 के बाद 16 है 11 के बाद 16 है bros. Only 1 minute.
नहीं 11 हमको समझ नहीं आ रहा है.
9, 10, 11 are tied up.
हो
And
गया
then
ना?
arising from the same FIR is another one at
16 को भी कर दीजिए. It is
But
submitted that
those
serial
cases
number
one and
16 में.
16
This may be tagged with जो BA number है इनका, ठीक है? Tag कर दीजिए. 12 नंबर. ये काउंसिल एकदम कंफ्यूज्ड हो गए.
Item 12,
Anybody would get confused.
So last day promotion of police to qualify the ones with the statement of the
आया? क्या बोलना है? Victim तो एकदम ऊपर गई. Heard the learned counsel opinion on behalf of the parties. The counsel for the petitioner submits that the petitioner has been falsely implicated in this case. He has submitted that, as per his information, even the victim has not supported the case. The learned counsel for the state, though has opposed the prayer for bail, however, he also does not dispute that the victim has not supported the prosecution case. पढ़ना चाहते हैं 183 BNC? After hearing the learned counsel for the parties and considering the statement of victim recorded under section 183 BNC, it appears that he has made a statement that her family members wanted to get her married without her consent, and therefore she went to Delhi and suo motu came back. And she has further stated that the name of 3 persons which have been against whom allegation has been made, 3 boys against whom allegation has been made, they have committed no mistake. Review order.
earlier bail also the annexure 2.
Annexure 2.
Annexure 2 में बाकी 2 का bail हो गया.
कोई बात नहीं. Considering the statement of the victim recorded under section 183 BNSS, the petition is directed to the national court.
Item 13, BA 3100 of 2026.
Cybercrime alert one criminal antecedent.
Antecedent crime कहते हैं.
See, therefore, my lord, the allegation in this case, if my lord will kindly see, my lord.
क्या antecedent है आपका? किस केस में?
Similar of cybercrime, 2021 का, that I will show.
क्या हुआ?
But इस case का allegation, my lord, it starts from page number 21.
ये tied up है क्या?
Antecedent cybercrime.
ये tied up है ये? और ABA है.
पुराना वाला, ABA.
बताइए.
इसमें नेचर ऑफ एलिगेशन इज
Page number?
पेज नंबर 21 में द एफआईआर स्टार्ट फ्रॉम पेज नंबर 19 लेकिन डिजिटल का जो है दैट विल स्टार्ट फ्रॉम पेज नंबर 21
बताइए पेज नंबर 21
मान
पकड़ाए गए व्यक्ति
1 सेकंड थर्ड आप पकड़ाए गए इसके बाद से मेरा शुरू होता है थर्ड पैराग्राफ सीलबंद एवं बरामद उपरोक्त सामानों को अपने कब्जे में लेते हुए उपस्थित गवाहों के समक्ष विधिवत कार्रवाई को ज्ञापन बनाकर स्वयं को दोनों ग्राम दुधानी थाना करम ब्रांच जिला जामताड़ा को गिरफ्तार किया और गिरफ्तारी की सूचना इनके परिजनों को दिया। पुनः ग्राम दुधानी में ही गुप्त सूचना मिली कि नारायणपुर थाना अंतर्गत ग्राम रुकनिया के अशोक कुमार दास अपने बेटे अंकित कुमार दास के साथ मिलकर घर में ही साइबर ठगी का काम करते हैं। क्या काम करते हैं वो आगे एक्सप्लेन। मिली सूचना के सत्यापन एवं आवश्यक कार्रवाई हेतु ग्राम दुधानी से छापामारी दल के साथ 7:45 बजे प्रस्थान किया एवं थाना प्रभारी नारायणपुर को निर्देशित किया कि अविलंब छापामारी दल में बल एवं स्थानीय चौकीदार के साथ शामिल हो। छापामारी दल के साथ करीब 18:30 बजे नारायणपुर थाना अंतर्गत ग्राम लोकनिया के अशोक कुमार दास के घर जैसे ही पहुंचे घर के अंदर एक कमरा में बैठे दो व्यक्ति भागने लगे, जिसमें से एक व्यक्ति को घेराबंदी किए हुए पुलिस बल के द्वारा पकड़ लिया गया एवं एक व्यक्ति भाग गया। पकड़ाए हुए व्यक्ति ने नाम पूछने का अपना नाम अशोक कुमार दास ने दिल हो चुका है उम्र स्वयं जामताड़ा बताया एवं भागे हुए अपने बेटे का नाम पता अंकित कुमार दास पिता अशोक कुमार दास ग्राम लोकनिया थाना नारायणपुर जिला जामताड़ा बताया। उपरोक्त स्थानीय ग्रामीणों में से किसी के द्वारा साइबर अपराधियों के भय से साक्षी बनने को तैयार नहीं होने पर स्थानीय चौकीदार स्वयं 2 नंबर बाबूलाल की सहमति से उन्हें तलाशी साक्षी बनाते हुए नियमानुसार पहले अपना एवं छापामारी दल में शामिल पुलिस बलों की तलाशी दिलाने के उपरांत पकड़े गए युवक एवं घटनास्थल से विधिवत तलाशी लेने पर पकड़ाए गए व्यक्ति अशोक कुमार दास स्वयं दाहिने हाथ से ओप्पो एंड्रॉइड मोबाइल से जिसका
तो जो भी रिकवरी हुआ है पिताजी से हुआ है।
My lord, he was not on the spot, so 2 or 3 things my lord I will submit my lord. But my lord nature और उसके बाद इनका रोल भी जो है वो भी आगे किया गया है कि they were never engaged with victims.
कोई विक्टिम मिला आपको?
विक्टिम नहीं आया लॉजिक, लेकिन इनके मोबाइल जो था उसमें दूसरे के नाम से था, उसमें एपीके फाइल था। एपीके फाइल में उस एपीके फाइल का जो लिंक भेजा जाता है, इसी लिंक को क्लिक करेंगे तो ऑपोजिट जो जिसको कॉल करते हैं उसका सारा डिटेल्स आ जाता है। दैट एपीके फाइल फाउंड इन दिस मोबाइल एंड अशोक कुमार दास फादर ऑफ दिस पिटिशनर स्टेटेड दैट दिस मोबाइल बिलोंग्स टू हिज सन, और एक सन का जो है इक्विवेलेंट सिमिलर नेचर का साइबर।
और जिसके पास से रिकवरी हुई है उनको तो बेलो।
हाँ, इनके फादर दोनों बाप बेटा रूप में थे, बेटा भाग गया, बाप पकड़े गया, बाप बोले कि ये मोबाइल जो है
मोबाइल किसके नाम से?
मोबाइल थर्ड पर्सन के नाम से नेम ऑफ फादर्स पर्सन।
The learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that, as per the FIR itself, the petitioner was not apprehended on this spot. Rather, his father was apprehended, and mobile/SIM has been recovered from his possession. The learned counsel has further submitted that, though the petitioner has one criminal antecedent, but there is nothing to connect the petitioner so far as the present case is concerned. No victim has been identified, and the mobile/SIMs were not recovered from the possession of the petitioner. The learned counsel for the state has approached the prayer for bail. It submits that the father, in his confession statement, has stated that the mobile belongs to the petitioner, and the petitioner has one criminal antecedent of similar nature. He further submits that APK file, AKP की APK?
APK.
APK app
Yes.
has been found in the mobile which has been recovered from the possession of the father of the petitioner. And the petitioner has one criminal antecedent of similar nature. To this, the learned counsel for the petitioner has submitted that the father of the petition has already been enlarged on bail. DA number? Ashok Kumar Das, na?
My lord,
In BA number 12021 of 2020. कब तक केस है? भागे हुए थे क्या?
30 सेक्रेटरी में माय लॉर्ड हमारे सेक्रेटरी आप तो रिजेक्ट हो
The charge sheet has already been submitted against the petitioner. After hearing the learned counsel for the parties and considering the fact that the person from whom the mobile /chains were recovered has been enlarged on bail by this court, and the fact that there has been no recovery from the possession of the petitioner and he could not be apprehended on the spot, the petitioner is directed to be enlarged on bail.
Item 14, BA 3236 of 2026.
According to apply Kapriya, the only allegation against the petitioner is running case 20. Even last शिवम सिंह बोलता था कि हमसे जबरदस्ती करो और हम अपनी गर्लफ्रेंड जिसका नाम सुरेंद्र है उसको छोड़कर तुमसे शादी करेंगे। इस प्रकार का दबाव बनाता था और बोलता था कि प्रियांशु साहब को कोई तो बिजी हो तो हमको भी भेजो, नहीं तो तुम्हारा वीडियो जो है उसको वायरल कर देंगे और तुमको बर्बाद कर देंगे। यही एलिगेशन पिटिशनर पे है। और मेरे पास से ना कोई फोटो है, मेरे पास जो सीज हुआ है मोबाइल फोन सीज हुआ है, इसमें ना कोई फोटो है ना कोई वीडियो है और ना ही इसमें कोई स्पेसिफिक मेरा कोई मोबाइल नंबर बताया नहीं दिया हुआ कि हम किससे फोन किए किससे क्या बोले। हम ट्वेल्थ का एक्सपीरियंस है और सिर्फ हम एग्जाम दी सभी से ही दिए, कल मेरा रिजल्ट अनाउंस हुआ है और हम उसमें पास भी किए।
क्या चीज़ में पास किए हैं?
ट्वेल्थ का एग्जाम सीबीएसई ट्वेल्थ क्लास का एग्जाम और
क्या बोल रहे हैं इनके ऊपर? क्या है
इनके ऊपर
ये बोल रहे थे कि आपको भेज दें?
ये रनिंग पेज 3 में है जो वीडियो और ये है इन्हीं से इन्हीं को मोबाइल से एक सीजन लिस्ट पे रखे खबर 183 भी सपोर्ट की है, हम पढ़ रहे हैं मिडिल में है। अदर सीजन लिस्ट showing seizure of the mobile of Shivam Raj, Shivam Singh and Ravi Kumar also available on record. The confessional statement of Shivam Singh, Sandeep Singh, petitioner is also available on record, wherein appears to have started above the involvement of himself as well as the other accused person in his occurrence. Further again, the statement of victim as recorded under section 183 of DNSS is also available on record, wherein she has supported the case of the story and stated that therein that Priyanshu Sahai had taken her photo through video call under force and threatening, and thereafter Priyanshu shared that recorded video to Shivam Singh, petitioner, who when started discouraging her to send other photos, otherwise he will make the earlier one viral. This fact also got to Shivam Bhumhar and Amit Rider, who then started to blackmailing her upon her refusal. Her video got viral by a accused person, which was seen by the friend of her. A specific allegation is there. One more thing, again he pressurized to compromise the case. Otherwise, शादी नहीं करने देंगे, वहाँ भेज देंगे, ये सब भी अभी हो रहा है।
इसमें कंफ्यूजन है लॉजिक। इसमें दो शिवम हैं जिनके बारे में ये बता रहे शिवम राज, वो जुबिलाई जैसे से उनका पेज अलाउ हुआ है। हम शिवम सिंह हैं, काउंटर एप्लीकेशन भी जो सबमिट हुआ है लॉजिक वो भी शिवम राज के अगेंस्ट
फाइल हुआ है नॉट
काउंटर
अगेंस्ट
एफिडेविट
नॉट अगेंस्ट द पिटिशनर
आप कौन है? आप स्टेट है? स्टेट कहाँ है?
हम इसमें
ये
शिवम
काउंटर
सिंह है
एफिडेविट शिवम सिंह के अगेंस्ट रिलेटेड नहीं फाइल हुआ है. He says that there are two Shivam. One is Shivam Singh and other is
शिवम राज
Shivam Raj.
पिटिशनर एक ही है लॉर्डशिप इनका पाया गया है लॉर्डशिप प्रियांशु जो है वीडियो बनाए प्रियांशु इनको दिए और ये जो है मोबाइल को वीडियो को भेजा
नहीं मेरे पास तो है
in investigation it has been found while connectivity between the petitioner Shivam Bhumiha and the victim.
कनेक्टिविटी है
The mobile connectivity between the petitioner
petitioner and the victim.
victim के साथ इनका कैसे? क्योंकि victim का तो allegation है कोई और इनको वीडियो कोई और भेजा है.
एक 12 में आया 48 में स्पेसिफिक उस लैंग्वेज को हम पढ़ते हैं पीडीआर आपका मोबाइल नंबर इतना कर प्राप्त सीनियर कॉलेज को ज्ञात हो जो मोबाइल नंबर कितना जो दो मोबाइल नंबर के बीच में बातचीत हुई है जो पीड़िता के विरुद्ध शिवम राज और शिवम भूमिहार के बीच बातचीत होना पाया गया वो मोबाइल नंबर इतना का धारक रंजीत कुमार है जो इनके पास से मोबाइल पाया गया वो रंजीत कुमार है थाना गिरिडीह है मोबाइल नंबर इतना का धारक नाम शिवम कुमार वो दूसरा मोबाइल
शिवम कुमार दूसरा है.
ये शिवम भूमिहार दो शिवम ये शिवम भूमिहार का
बातचीत हुआ है लेकिन ऐसा तो victim has not forwarded the video to him. Rather, Priyanshu had forwarded the video to him and he has made it viral.
इसमें एक चीज है ना
इसके बाद
ये जो बता रहे हैं
स्पेसिफिक एलिगेशन है कि शिवम भूमिहार उनको कंपेल कॉन्ट्रैक्ट करता था यू विल मेंड द रिलेशन विद मी दैट आई विल
ये अभी भी कंफ्यूज है राशिद हम बता रहे हैं इसमें कि ये रंजीत कुमार जो बता रहे हैं शिवम भूमिहार जो फादर देश में है पहला बच्चे जो बताए तो तीसरा का फादर का नाम है संदीप सिंह नॉट रंजीत कुमार और शिवम क्योंकि दोनों का इलियास में एक शिवम राज इलियास शिवम भूमिहार है राशिद और शिवम सिंह इलियास शिवम कुमार भूमिहार है शिवम भूमिहार दोनों का इलियास में शिवम भूमिहार है राशिद और ये जो बता रहे हैं सर इसमें ये जो
कस्टडी कब से?
17/2/26 से
17/2/26 आपका चार्जशीट हो गया?
जी
हो गया चार्जशीट हो गया इनका?
For
the learned counsel appearing on behalf of the party, the learned counsel for the petition submits that the petition having no criminal antecedent is in custody since 17 to 2026 and charge sheet has already been submitted. He has submitted that as per the allegation, the victim was being pressurized by the petitioner to send her obscene video, but the petitioner received the obscene video of the victim from one Priyanshu. And as per the allegation, the petitioner had made the video viral. And as per the statement of the victim, Priyanshu Sahai had taken the objectionable video of the victim. The learned counsel for the state has opposed the prayer for bail and has submitted that video has already been recovered from his mobile.
No, ma'am.
However, the aforesaid submissions made by the petitioner is not in dispute. In view of the fact that the petitioner has no criminal antecedent and charge sheet has already been submitted, the petitioner is likely to gain maximum.
Item 15 PA 1136 of 2026.
Yes, what is this?
Petitioner is the mother-in-law.
Died within 3 months of
Months.
marriage.
Yes, that is not easy. But the reason for committing suicide, she had committed suicide because of the neglect by the father and mother, family members. There are paragraphs below in which the witnesses have said there was good relation between mother-in-law and the deceased mother. Because love marriage, she has recognized love marriage with the son of the petitioner. Therefore, they were annoyed and they were not talking with her. She committed suicide. This is the
There is allegation of demand of dowry.
demand of dowry, but that is general omnibus allegation against
जनरल ऑमनिबस नहीं होता डिमांड ऑफ डाउरी, बहुत सीरियस होता है डाउरी डेथ में.
But dowry death is
304B में
yes, yes.
सारा ओनस आपके ऊपर है.
Onus is upon me, but she is a mother-in-law. There is no
Completely dying within 3 months of her
that
marriage.
is there are so many causes. But she had solemnized love marriage, and her parents was not happy with this. Because of this, she had committed suicide via miscarriage.
Or the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that though the victim was found dead in matrimonial home within 3 months of marriage, but the reason for death was that she was being neglected by her parents as she had performed love marriage. He says that the petitioner is the mother-in-law of the victim. The learned counsel for the state has opposed the prayer for bail and has submitted that there is direct allegation of demand of dowry in the FIR. After hearing the learned counsel for the parties and considering the fact that the victim died in a matrimonial home within 3 months of marriage, and there is direct allegation of demand of dowry, this court is not inclined to enlarge the petitioner on the basis.
Item 17, DA.15.05.2026. of 2026.
So here the petitioner had moved to the position of the court, which when the therefore bill was executed withdrawn.
Item 17.
Dismissed on basis. Order is at page.
Yes, it was earlier dismissed as withdrawn.
The learned counsel for the petitioner, the petitioner state, the petitioner is filed at now. Commissioner, please allow me. On that, I read that we are not happy.
Okay. So, what do you have to say?
Yes. But the first information report has been lost against 228 named persons, also against 300 unknown persons, and also against several other persons.
228 named
Named
persons.
persons.
And how many unknown?
About 200 to 300 more unknown persons were.
क्या मैटर है सर?
But the allegation is not that the members of the Tana Bhagat, the informant got information that they are members of the Tana Bhagat are coming towards the civil court premises of Lateha, having armed with the traditional weapon ballots to protest against the government ballots, and thereafter they assembled, and when they were stopped ballot, that thereafter some students created ballots, and the first information report has been lost against about 500 persons were there. This is an old man, aged about 76 years, and several other accused persons ballots. I managed the order granting bail.
क्या नाम है इनका?
Persons have been granted bail.
परमेश्वर ताना भगत. कहाँ है आपका नाम बताइए?
Now,
FIR में नाम बताइए.
yes, serial number 36.
जिसका नेतृत्व परमेश्वर ताना गश्त कर रहे. You were leading the.
But name marks the, as per the first information report that
बहुत serious है.
almost all no injury has been caused marks.
इंजुरी का जरूरत नहीं है ना.
खाली वही है, at best 147, 148, 149 का है, allegation है. That is the allegation. That is the allegation marks.
That's
But rather we sustained injuries marks. He has got no criminal antecedent. कल एक लाइन लिख दिया नेतृत्व कर रहे थे. My age is 72 years of age. He is marks. उसको इंजरी होना चाहिए, कहीं तोड़ फोड़ तो होना चाहिए. On this the statement marks of the circle officer. Rather we sustained injuries. हम लोग मारा गया वहाँ, उसके बाद they left it away from their homes. स्पेसिफिक तो इसलिए आए, एक लाइन शुरू में खाली लिखे नेतृत्व करा था, thereafter there is no allegation. कोई आर्म नहीं थे ये लोग, डेडली वेपन से, कोई एक्सप्लोसिव सब्सटेंस इन लोग के पास नहीं था. ट्रेडिशनल वेपन जो है तीर धनुष लेकर वो they had assembled. And he is not going to abscond.
हम लोग संविधान को नहीं मानते हैं, असंवैधानिक और अवैध है. हाँ, आपको देखने दे सकते.
और तो सबको हो गया है इसमें तो.
कोई बात नहीं, सबको
हो गया है. उसमें क्या एलिगेशन जो स्पेसिफिक किया है, that is not a
नहीं सर, मेरा मन नहीं माना.
That is different, but coordinate benchmarks having.
हाँ, I will take care of all the orders.
About 50% have been granted bail in this case, as per my instruction.
कहाँ है?
हम लगा लेंगे उसको करके, उसमें लगा है. Annexure 2, 3 to 8 I have mentioned marks, and also I have got
For the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that.
One thing more marks, that the
though alleged offence is under section 326 and 307 of IPC.
Maybe hard marks. 326 and 307 का केस नहीं बनता है. Concerning all these things, one of the other accused persons have been granted. In no case is made out either under section 326 and 307, and the other sections are almost available in each marks. No arms act case has been instituted. This was the consideration of this honorable court for grant of bail.
The learned counsel for the petitioner has submitted that no case under section 326 and 307 of IPC has been made out in the present case. He has further submitted that on the alleged date of occurrence, about 228 named and 200 to 300 unknown persons forcefully entered the civil court Latehar, and it is alleged that they caused hurt to several executive officials and members of the police. And abused judicial officers including Principal District and Sessions Judge Latehar and members of administration. And they were repeatedly asserting that the function of the court and work of administration was unconstitutional. As per the allegation, they forcefully entered and caused damage to the court documents and public property, and after forming unlawful assembly. The learned counsel has and it is also alleged that they entered with dangerous weapon like Tami and caused serious injuries to their persons, and officer in charge of the police station also sustained injuries on his nose when an attempt to hit him with the above weapon on his head was made. The learned counsel for the petitioner has submitted that a large number of similarly situated persons have been enlarged on bail by different coordinate benches. And the petitioner is 76 years of age.
76 years.
76 years of age. Some of the bail orders have been placed on record. The Learned Counsel for the state has opposed the prayer for bail and has submitted that as per the allegation, it was the petitioner who was leading the entire
Sorry
crowd.
for interrupting. That in this point, follow my
For
submission
the-
is at this that allegation is I'm placing words. नाजायज मरवा बंद है उसका नेतृत्व जिसका नेतृत्व परमेश्वर टाना भगत बाबूलाल टाना भगत बहादुर टाना भगत जयमंगल टाना भगत धनेश्वर टाना भगत प्रभुदयाल टाना भगत रामनी उराव महेश्वर 28 persons are named that they were leading the mob. 28 persons. Page 14.
He submits that petitioner along with 28 named accused persons were leading the mob, and in such circumstances the petitioner may not be enlarged on bail, and the allegations against the petitioner are very serious.
When it travels, that may be.
After hearing the Learned Counsel for the parties and considering the fact that the petitioner is a named accused person who was amongst the persons who was leading the mob who committed the alleged offence, this court is not inclined to enlarge the petitioner on bail instead.
Committee DT.15.05.2026.
Yes.
One of the co-accused similarly situated has been granted bail. I have annexed the order annexed to page 22.
Annexed to page?
Page 22.
Who is that similarly situated accused?
Mr. Kumari, the petitioner is not named in the FIR.
Just a moment. 20. There is no recovery.
No TIP.
No recovery, no TIP.
I have stated in paragraph 15 about TIP.
Is it identically this? For the Learned Counsel appearing on behalf of the parties, the Learned Counsel for the petitioner submits that the bail application of the petitioner was withdrawn earlier in DA number 11.12.05 of 2025 by the order dated 18/2/2026. However, the co-accused has been enlarged on bail, namely Prabhat Kumar Yadav in DA number 679 of 2026 by the order dated 22/4/2026. The Learned Counsel submits that the case of the petitioner is on identical footing and there is no recovery from his possession and no TIP has been conducted, and except confession statement there is nothing against the petitioner. Any antecedent?
Antecedent? He is having antecedent. I have stated in paragraph 18.
Have you been enlarged on bail in those cases?
Yes, in 2 cases.
How many cases do you have?
Total 21 cases.
21 cases.
The co-accused also has cases. Kindly have a look at one of background.
That's it. The Learned Counsel for considering the fact that similarly situated person, namely Prabhat Kumar Yadav, has been enlarged on bail, the petition is also directed to be enlarged on bail. Chargeशीट हो गया ना आपका? बता.
28
Good enough.
Article 19 DT.15.06 of 2026.
Yes, please.
Case of 302 not named in FIR. Suspicion has been placed in the FIR. One Mirago.
Yeah, they have dismissal.
No, dismissal.
dismissed and not pressed.
Not pressed because उस समय preliminary stage का 3 witness होने के बाद again we are moving your lordship for consideration of bail. On earlier occasion it was simply not pressed.
अब 3 विटनेस हो गया है तो कितना विटनेस बचा है?
Witness हो गया 3 witness का सीजन पर
हाँ टोटल
8 witness.
8 witness.
एक डॉक्टर हो गया, एक आईओ हो गया,
आयो हो गया और इन्फॉर्मेंट हो गया, सब बाकी
बस 3 ही तो है। बताइए कब विटनेस कराना है? नहीं नहीं हम डायरेक्शन देंगे ना, आपको क्या लग रहा है? मेरे डायरेक्शन का कोई वैल्यू नहीं है। जैसे बोलेंगे तो बिना केस डायरी के हम क्या कर सकते?
केस डायरी कॉर्फर है
नहीं
Lordship, इसमें include order है on the disclosure of the petitioner, the motorcycle of the deceased, and as well as the clothes and slipper of the petitioner used on date of the occurrence were recovered and seized on the basis of the disclosure of the petitioner.
सबको बहस ही नहीं करनी चाहिए।
हो गया अब केस डायरी
मौन धारण कर दिए। अब क्या बोलें?
हमारे पास केस डायरी है, हमको पेपर
हमारे पास नहीं है ना सर।
पुलिस पेपर में ठीक है।
Let the case diary be called for from the concerned. Counsel for the state is directed to file a counter affidavit in this case along with the criminal antecedent report of the petitioner. Case diary along with the postmortem report.
Article 28.
16 June और पहले चाहिए बाद में चाहिए? Along with the stage of the case भी मंगाइएगा। 16 जून?
ठीक है जी लॉर्डशिप।
16
बिकॉज़ ऑनगोइंग ट्रायल है, स्टेटस भी मंगाएगी।
इसीलिए स्टेटस मंगाएंगे 16 जून। आपका काम बन गया ना?
काम कहाँ बना है?
रिजेक्ट नहीं हुआ और क्या काम चाहिए?
काली बिलाई से रास्ता छेड़
हम लिटिगेंट का काम नहीं बोले, आपका काम।
शांति से गुजरेगा तो
बस ठीक है।
Article 28 BA 3642 or 26 along with Article 21.
Yes, petitioner.
First case, three mobile with 4 SIM. No antecedent, my lord.
3 mobile.
Yes, sir. 3 mobile.
And
4 SIM.
4 SIM.
Yes, my lord. And there's 5 victims, my lord.
No, and 5 victims.
Yes, my lord. Total gain सब victim मिला के 33,594 rupees.
सारा
सब मिला 33,590. पहला victim का
ऐसा तो नहीं है कि बेल से निकल के इम्प्रूव कर लेंगे अपना अमाउंट में? नहीं करिएगा ना?
कोई antecedent.
एंटीसीडेंट वाले तो सब अभी वेकेशन में फाइल करेंगे। ठीक बोल रहे हो ना? They're waiting. कितना क्राइम लिंक है इनका?
इनका क्राइम लिंक 7 क्राइम लॉर्डशिप 3 मोबाइल सेट और 3 सिम पाया गया है, जिसमें से सम सिम्स आर इन नेम ऑफ अदर। 7 क्राइम लिंक पाया गया इनके अगेंस्ट में और देयर आर 5 विक्टिम्स।
एफआईआर है कोई?
एफआईआर कोई
heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 21/26.
21/1/2026.
21/1/2026. And 3 mobile 4 SIMs are alleged to have been recovered from the possession of the petitioner, and total 5 victims of very small amount each have been identified. He submits that the petitioner has no other case instituted against him. The counsel for the state has opposed the prayer for bail. However, the apostate submissions are not in dispute. He further submits that altogether 7 crime links were found. After hearing the learned counsel for the parties, charge sheet submitted. And the charge sheet has already been submitted. After hearing the learned counsel for the parties and considering the fact that charge sheet has already been submitted and there is no criminal antecedent of the petitioner is directed to the investigation.
सेकंड केस में 2 मोबाइल में 2 सिम उसमें 4 विक्टिम।
आप जो इतना कर रहे हैं काम, इनसे सीख रहे हैं कि नहीं कैसे करते हैं, तब ना आपको पकड़ होगा सब्जेक्ट का।
I'm understanding how the state can work on it.
No, sir, I'm not saying that you will commit crime.
No,
what I'm saying is that you should understand what they are doing.
Yes, ma'am, that's why we should be one step forward.
Yes.
We are 2 steps back.
बताइए क्या क्या मिला?
2 mobile with 2 sims.
2 mobile, 2 sims, and
4 victims.
4 victims. Amount कितना है?
इसमें एक में है 1,05,000, एक का है 1,24,000 और 1,500 और 14,600।
ज़्यादा नहीं है?
इसमें बहुत ज़्यादा, लेकिन नो एंटीसीडेंट, कोई केस नहीं।
चार्ज पेन हो गया?
हाँ, आज चार्ज के लिए रखा। चार्ज के केस।
क्राइम लिंक कितना है इनका?
One complaint has also in technical verification. 5 complaint पाया गया है CRP पोर्टल पर subsequently during investigation.
Or the learned counsel opinion on behalf of the parties.
4 victims.
The learned counsel for the petitioner has submitted that 2 mobiles, 2 sims are alleged to have been recovered from the possession of the petitioner and 4 victims have been identified.
जिसमें से 2 1 लाख रुपए से ऊपर.
And there is no criminal antecedent. The counsel for the state has opposed and charge sheet has been submitted. The counsel for the state has submitted that there is 1 complaint lodged against the petitioner and 5 complaints. And thereafter 5 complaints have been found in the portal. And amongst the 4 victims, the amount involved is more than 1 lakh with respect to 2 victims. Considering the materials collected during investigation against the petitioner, the state is not inclined to enlarge the petitioner on bail at this stage. However, the petitioner may renew his prayer for bail after 6 months.
इसमें 1 mobile with 1 SIM and there are total 2 victims. Total amount है 30,000.
1 mobile, 1 SIM, 2 victims, 30,000. No antecedent.
No antecedent.
Charge sheet submitted.
हाँ, charge sheet same
हाँ बताइए. Yes, state.
Mostly there are crime link again.
How many?
1 crime link lodged. During investigation, 6 another crime link found. And 2 victim traced out 8,250 को 19,925 2 victim.
दोनों मिला के 30,000.
दोनों मिला के हो गया 30,000.
Heard the learned counsel's opinion on behalf of the party. The learned counsel for the petitioner submits that 1 mobile and 1 SIM are alleged to have been recovered from the possession of the petitioner, and the petitioner has no criminal antecedent. 2 victims for total of rupees about 30,000 have been identified. The charge sheet has already been submitted. The learned counsel for the state has opposed the prayer for bail and has submitted that altogether 7 crime links have been found, but the aforesaid submissions are not in dispute. After hearing the learned counsel for the parties and considering the fact that charge sheet has already been submitted, the petition is directed to be enlarged.
Item 23, BA 3646 of 2026.
In this case, 1 mobile with 1 SIM recovered, only 1 victim of 2,100.
1 mobile, 1 SIM, 1 victim, no antecedent.
No antecedent, charge is submitted, 2,125 rupees.
ये सही बोल रहे हैं? Heard the learned counsel appealing on behalf of the parties. The counsel for the petition submits that the petition having no antecedent is in custody and charge sheet has already been submitted. As per allegation, one mobile, one SIM has been recovered from the possession of the petitioner and one victim has been identified. The counsel for the state has opposed the bail, but the posted submissions of the petitioner are not in dispute.
मोबाइल सिंह किसी और के नाम है।
Sorry?
मोबाइल और सिंह किसी और के नाम है।
We have submitted that the mobile and SIM was not in the name of the petitioner.
Several calls reached here.
Sorry?
Several calls reached here.
बहुत तो रीच करेंगे तब ना एक हिट करता है. That means that there are several crime links.
Yes.
But only one victim could be identified. After hearing the counsel for the parties, the charge sheet having been submitted and the petition having no criminal antecedent, the petition is directed to the national.
Item 24, BA3760 of 2026.
Yes, petitioner.
Last day, notice was issued upon the victim to the state which they had brought a counter affidavit that it has been served duly to the police station. But no wakalatnama has been filed.
It's okay if she's not interested. If she's not interested, we can't do it.
It was served yesterday. Nonetheless, the case diary has come. I have perused declaration. Clearly, so the incident, alleged incident took place on 10th May. On 11th May, she got a medical examination done. And the medical examination report, which is at para 26 of the case diary.
10/5/25.
10/5/2025, the incident
Medical?
took place. And the medical examination was conducted on her the very next day, which is on 11th May 2025. And with the medical examination report, which is dated 13/5/2025 at para 26 of the case diary may be seen, it shows that the conclusion that was drawn was that it doesn't seem, it is difficult to say whether rape has occurred or not.
Medical report is not the conclusive.
Yes, but there was no external injury also found, and there are certain inconsistencies from the first glance that I could make out. Is that in her FIR she said कि मुझे boot को उठाकर he took the bushes, and there she said हाथ से
She has fully supported the petition.
That is it.
Or the learned counsel's opinion on behalf of the parties. The learned counsel for the petitioner submits that the alleged incident is dated 10/5/2025 and the medical examination was conducted on the next day, that is 11/5/2025, but no external injury has been found and no
The conclusion is that it cannot be said.
and it could not be said as to whether rape has been committed or not. The counsel for the state has opposed a prayer for bail. The statement of the victim recorded under section 183 BSS has been placed on record, and there is direct allegation against the petitioner. In her statement, in the statement under section 183 BSS, in view of the serious heinous nature of offence, this court is not inclined to enlarge the petitioner on bail. What do you want from me?
The trial will be expedited.
This counsel for the petitioner submits that the trial will be expedited.
Given the fact that
Considering the submissions, the state is directed to ensure that the witnesses are promptly produced before the court. The counsel for the state is directed to communicate this order to the SP of the concerned district and to the director of distribution.
Item 25, BA3706 of 2026, along with Item 26.
Yes. Injury is grievous.
Injury 1 and
What is the nature of allegation? Allegation क्या है? बोलिए।
पेज नंबर 22
FIR खोलिए, FIR
पेज नंबर 22 का एफआईआर का हम कारण
read it please.
थोड़ा सा ये अपने को बढ़ गया
क्या नाम है आपका?
कोरिकुल से बरिया सही अपना अपने हाथ में घातक हथियार लगा रहे थे। मेरे पुत्र को कोरिकुल शेख ने मेरे पुत्र पर चाकू से प्रहार किया जिससे मेरे पुत्र का बायां हाथ घायल हो गया। आतिकुल शेख ने छेनी से प्रहार कर मेरे पुत्र पर दायां हाथ घायल हो गया। ऐसे के हाथ में गुजारी था जिसने मेरे पुत्र के चेहरे पर प्रहार किया जिससे मेरे पुत्र को गाल काफी घायल। Essence Sheikh has been granted anticipated.
Who?
Essence. Election series.
Atiku Sheikh.
Yes.
Atiku Sheikh has been granted anticipated.
No. Essence Sheikh. Essence Sheikh के हाथ में गुजारी था जिसने मेरे पुत्र के चेहरे पर प्रहार किया जिससे मेरे पुत्र का गाल काफी घायल हो गया। ये granted है. Election series में. कोई होता है हम गैरेंटेड एंटीसिपेटरी इन को हुआ है रेगुलर के सीरीज याशीन शेख और हम लोग 4 आए थे एंटीसिपेटरी में उससे 2 लोगों को बेल दिया था 2 लोगों को इसलिए हम लोग आए।
आपका रिजेक्ट हो गया था ना आप ही को गए
जी उसके बाद हम लोग रेगुलर मिला है।
पिटिशनर नंबर ये इन सब का बिल आपका भी तो सबके साथ रिजेक्ट हुआ था।
ये 104 आदमी के
There are allegation against petition number 1 and 3 of assault and molestation. 1 and 3 आपके ऊपर assault and molestation.
2 and 4 को बेल मिला 2 and 4
and suffering grievous injury.
Injury in the wrist.
नहीं hand
Custody कब से है? Anticipated.
28 no and
28
3
2026. इनको जो ग्रीवियस इंजरी हुई है ना आप ही के इंजरी से हुई। तौसीर शेख ने मेरे पुत्र पर चाकू से प्रहार किया जिससे मेरे पुत्र का बायां हाथ घायल हो गया। The learned counsel for the parties are present. The learned counsel for the petitioner submits that the petitioner is in custody since 28/3/26. चार्जशीट हो गया आपका?
नहीं चाहते
चार्जशीट पे बनाने के
हम करवा डायरेक्शन दिया जाए
हम क्या डायरेक्शन देंगे?
लेकिन अब हो जाए
चार्ज प्रिंट करने के बाद आइएगा तब ये ऑब्जर्वेशन देंगे।
हम इंस्ट्रक्शन लेना
इंस्ट्रक्शन का जरूरत नहीं
इसके बाद
और
आपने वैकेशन कर दिया
नहीं काउंसिल फॉर द पिटिशनर सबमिट्स दैट द
चार्जेस हुआ नहीं खबर ले लेते
कोई जरूरत नहीं है हो गया होगा तो दोबारा आ जाइएगा।
एक सेकंड आप रख दिया जाए
नहीं सेकंड हाफ में कुछ हम लोगों को दूसरा काम है। Petitioner is in custody since 28/3/2026 and the anticipatory bail has been granted to other co-accused but the anticipatory bail of the petitioner was rejected. He submits that the petitioner has been falsely implicated in this case. the learned counsel for the state has proposed a prayer and has submitted that the petition, as per the FIR itself, the petitioner is said to have assaulted the son of the informant on his by knife on his left hand, and as per the injury report, the injury was grievous in nature. Considering the direct allegation made against the petitioner, this court is not inclined to enlarge the petitioner on bail at this stage. However, the petitioner may renew his prayer for bail after framing of charge. चार्ज फ्रेम कराइए, आ जाइए, छुट्टी में करा लीजिए चार्ज. ये दूसरा आपकी सेम FIR, इनके ऊपर क्या एलिगेशन है?
शनि से साफ करते हुए शनि से मेरे को आया था.
The learned counsel for the petitioner, इनका भी एंटिसिपेटरी बेल रिजेक्ट हुआ था. सेम ऑर्डर कर दीजिएगा, है ना? एंड द विक्टिम सफर्ड ग्रीवियस इंजरी. तो स्पेसिफिक मत लिखिए. फ्रेमिंग अब चार्ज फ्रेम करा के आइए, एंटीसीडेंट नहीं है. एट दिस पड़ोसी है ना, थोड़ा सा रह जाइए, शांति हो जाएगा.
Item 30 DA.15.05.2026 of 2026.
Yes.
Allegation in the petitioner is that he called the victim girls and made a force liquor and made a relationship with them. However, the medical report and the opinion of the doctor, which suggests that there is no sexual assault happened with the victim's person. And liquor also has been noticed by the IU lordship, and petitioner has had no criminal antecedent.
What is the medical report?
Medical report case diary केस नंबर 1242 में केस डायरी लिखा हुआ है और पहले से दोनों जान पहचान थे.
This incident is of 1126. She was examined on 15th of January.
Girl was about to 18 years old. More 17 years 3 months. And delay FIR was lodged after 12 days. Delay FIR.
Reason for delay is also there.
No.
In her statement under 183 BNSS, she said that he forced her to consume liquor, but further there is nothing.
Liquor was not recovered.
No, further there is nothing. पीना पड़ेगा, वो जबरन शराब पिलाया और मैं बेहोश हो गई. जब होश आया तो मैंने अपने आप को सदर हॉस्पिटल. क्या बोलेंगे? मेडिकल तो नहीं सपोर्ट कर रहा. That is delay.
14 days बाद हुआ है.
14 days बाद में हुआ. डिले भी तो भारत मतलब FIR भी डिलेड है.
Because after she consumed liquor, because she became unconscious. So and thereafter she was taken to the hospital and she was there till 10th June. Then she got discharged. Thereafter this FIR.
She was there for what treatment? Liquor होने से तो नहीं होगा ना. What was the treatment she was undergoing? वहाँ से तो मेडिकल का कोई डॉक्यूमेंट नहीं है कि क्या चीज का इलाज हो रहा था. What have you done? क्या किए आप? 10 दिन वो जब जेल में वहाँ रही हॉस्पिटल में, she must have suffered something. How do you know what she suffered? उसमें भी कुछ नहीं बोली है. From where do you say that she was in the hospital for 10 days? Where is it? पेड़ के पास बेहोश पड़ी है, उसके कपड़े आधे खुले हुए हैं और पास ही शराब की बोतल और समोसा चाउमीन पड़ा हुआ है।
But she was not sick by the eye.
Because some of the witnesses, they have stated that the petitioner he came to them and informed that the girl has become unconscious and then he died.
What was the reason for unconscious? Reason is not accepted.
This para 49 of the diary suggests that she was in the hospital. In 181 plus she has said that rape was committed upon her. 183 statement plus I don't have. 181 she has supported the prosecution.
इस सदर अस्पताल में भर्ती से संबंधित कागजात की छायाप्रति कांड दैनिकी के साथ संलग्न है। Where is that?
This is not with the diary.
So, it's not that nothing has been recovered.
Nothing regarding
एक पेज लगा है उसपे
charge sheet is already submitted also.
जो शांति रखिए ना, बहुत अच्छा एलिगेशन तो नहीं है, बेल देने के लिए सोच के देना पड़ता है, रिजेक्ट तो 1 मिनट में हो जाता, थोड़ा शांति रखिए। इसमें भी तो कुछ नहीं है। Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that, as per the allegation, the petitioner and the victim were known to each other, and on 1/1/2026, the petitioner went for picnic. No, the victim went for picnic with the petitioner, and it is alleged that the petitioner forcefully got liquor consumed by the victim, and thereafter she became unconscious and she was raped. The learned counsel submits that the medical report does not support the allegation, and the charge sheet has already been submitted. The petitioner is in custody since 15/1/2026. The learned counsel for the opposite party has opposed the prayer and has submitted that after the incident, the victim was taken to Sadar Hospital and she remained in the hospital for 10 days. And the document regarding her treatment has been collected, and in the case diary, the document, however, the document annexed to the case diary does not reveal the detention of, does not reveal that the victim remained in the hospital for 10 days. नहीं पता चल रहा ना इससे? नहीं, document से नहीं पता चल रहा. She has further submitted that the medical examination was conducted after 15 days of documents. To this, the counsel for the petition submits that there was delay of 12 days in filing the FIR. The statement of victim recorded under section 183 BNSS has been placed on record, and upon perusal of the same, apart from the allegation that the petitioner forcefully got liquor consumed by the victim and she became unconscious, there is no further allegation. When she gained consciousness, she found herself in Sadar Hospital. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances and charge sheet and charge sheet having already been submitted, The petitioner is directed to be enlarged on this. कितना बच्चा केस?
Item 31 DT.15.05.2026.
Yes, please. Answer,
The
बोलो.
petition is for grant of regular pay. The offence alleges in 103(1) and 3, section 5 of the DNA. In this case, the Khizari postmortem report was called for and the deputy was directed by the counter evidence.
You have filed your counter. PD file किया.
क्या हम लिखते हैं?
हाँ?
क्या हम इसके बारे में लिखते हैं? जरा सा अपने परेशान.
नहीं.
तो आप ही का डॉक्यूमेंट है.
सब चीज ठीक है किंतु क्या लिखें? हम अपने नहीं पढ़ पा रहे. खाली एक लाइन ऊपर में लिखा हुआ है स्लॉट लिंग उतना बार खाली पढ़ पाए. जो भी डायरी
खिजारी और पोस्टमार्टम रिपोर्ट दोनों ही मांगा गया.
तो लिखा ही हुआ है हमारा में तो बढ़िया है ड्यू टू द ओपिनियन ऑफ कॉज ऑफ डेथ ड्यू टू सफोकेशन ड्यू टू थ्रोट.
गवर्नमेंट के लॉयर को भी बहुत बढ़िया कॉपी बन गया है खिजारी का ऑलरेडी किसी को
अब जो हो जाएगा है
नहीं हम नहीं बोल रहे हैं वो बोल रहे हैं.
हम
ये बोल सकता है ये कुछ काउंटर पे हो या फिर
हां ठीक है हमको उसमें कोई ऑब्जेक्शन नहीं है. से
Suffocation and suffocating is the cause of death.
हाँ.
क्या है सर इसमें?
This petitioner blood is the father-in-law, and the deceased blood had died in the matrimonial house when she had gone along with her own mother. Lord, she was residing prior to Lord death with the husband Lord in Chennai, where Lord the husband was working. When she
had
became
gone to Chennai.
No, Melody, Chennai, Melody, she was residing with husband in Chennai, when she became Lord the pregnant. Then Lord the, she was sent by her husband to her back. Lord the child was delivered. After Lord the 3 months, about 2 to 3 months, the child was died. Then Lord the father-in-law, after getting information, had gone to Lord the Sandhyana, the neighbor of Lord the deceased, and there Lord the he came to know that Lord
सर
the
अब छुट्टी की बात करिए. 1:45. नहीं छुट्टी बात करिए. The no counter affidavit has been filed by the state. The council for the state is directed to seek instructions and file counter. Post on 9th of June. 9th June.
क्यों? सेकंड आपका जो लिस्ट हो जाएगा बहुत ही अलग
modification of the study matter. Serial number next question था.
सारा केस तो कंप्लीट हो गया. वोट एग्जॉस्ट कर गए. कौन सा केस है बोल रहा है?
हम लोग गलत में किए.